set up. Yeah. I think, well, it's Witness Center.
Oh, yeah, he's prosecuting.
Yeah. I don't think you're old, but probably never let you into, but whatever. But yeah, it was hard to work to focus on traffic.
Oh, my God. Actually, I feel like there was something we talked about, like when, like, it was like, did you mention part 150?
Yeah.
Speaking of.
Speaking of. Hey guys. Hey.
Hey guys.
How you doing?
Hey.
Oh, you know, pretty good. How are you?
Side, pick your side.
I think we're this side.
Hey, you guys are that side.
Good to see you.
Good to see you
Always a
guys.
pleasure.
Side.
Good to see you.
In the front.
Looking sharp. I like that we're color
Yeah.
coordinated somehow.
You guys look good too.
Yeah, you guys are
Hey,
colorful.
we did it.
You guys look very much like prosecutors.
Yeah, you guys
Good.
look like the bad guys, and we look like the good guys, you know?
Yeah.
We prefer to think of it as providing justice,
Yeah,
not
okay.
the bad guys.
Well, that's your
okay?
interpretation.
Taking away liberty from Tony Grove.
Well, you know, he kind of brought it upon himself. Just a little bit. Did you guys get water bottles?
We have one.
We got
Do you
one.
guys need another one?
If you haven't, if you have your own,
Yeah,
sure.
I have my own.
Thank you.
Yeah.
Cold water for the finals.
No, we're getting a little VIP treatment.
Let me run to the bathroom, then we could do stipulations and stuff.
Okay, I guess somebody was supposed to help us set up the microphone, but maybe
Yeah, I
that's...
think we might not be doing one. I don't know, maybe now to go back, here's my job.
Seems like it's on. Hello?
I think they're gonna give us, I think they're gonna give us like lapel mics.
I was under the impression that someone
Oh,
was getting
boy.
mic'd. I don't know if it was supposed to be me or not. Yep, that's definitely on.
Test, 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 test. Come on.
Test it.
Can you hear me?
I think I need it up more.
Can you hear me?
I think it's on.
Anyone can hear me?
Is this doing
It's not
anything?
going up.
That's on. That's working.
Hello?
Test now.
Hello? Hello?
Test, test, test. Whoa.
I can turn it up a little too. It's
Test, 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 test. Good.
I don't think this is maybe just a little bit.
testing. That works. Yeah, I can hear myself.
In like mic wise. Yeah, it's still okay.
Testing. Okay, this one's working.
Test. And now, like what? It's just. I think I'm like creating like a funnel down into it with my hand. Yeah.
Hello. Yep, that's definitely working. Now we're talking. Yeah, that's better. Wow. I sound all loud. Hey. I don't think it's on. Did I turn it on? Objection. Now I hear it. Huh, that's weird. Objection. Now I hear it. Good morning. Your Honor. Yeah. Check the level. Don't blow out anybody's eardrums.
Hello? Oh.
They're working?
Oh, yeah.
Plan to stay, you're totally welcome to come up. You might be able to hear better, thanks for a better view. Just so you guys know, we will be taking a bathroom break at like halftime. So Colorado Law School. I would like to thank everyone for being here today. Congratulate our finalists. These are 1L students who worked tirelessly to get here. I also wanted to extend gratitude to our judges for being here today, without whom this would not be possible. The firm of Purvis Gray Thompson generously has funded this competition, so we obviously owe our thanks to Purvis Gray Thompson, and Mike Thompson on behalf of the firm is here. Finally, this whole competition was put together by a third-year student. Lauren worked tirelessly to make this possible, and she did a phenomenal job. I've worked with students for a decade, and she's definitely like way up there among the students who are organized and have everything planned, so we thank Lauren as well. We will have a break at halftime, so if anybody has to go to the bathroom, don't worry, you don't have to sit here for the next 4 hours without any kind of a break. The whole thing won't be that long anyway, don't worry. So a few housekeeping items. Number one is, if you can, please make sure your cell phones are turned off or on silent. We need to show our respect to the competitors and to the judges. This is being recorded and live streamed. That will not affect you, but we just want to let you know. And then I think that's it. The judges will explain the rules. They will be keeping score. And once the arguments are over, the judges will go back into judges' chambers to deliberate, and then they will come out and give us the ruling, and they will give you some feedback. We are going to have a reception immediately outside of the courtroom after the round is over. Please, we encourage you to stay for that. We'll have great food, and we'll have drinks. Okay, without further ado, I turn it over to our judges. Good luck, competitors.
In that case, at this point, we'll call the State of Lone Star versus Tony Grubb. I'd like to start with entries of appearance by counsel, beginning with the prosecution.
Rami Jordan for the prosecution. My co-counsel, Anna Zinman.
And how do we spell, I'm sorry, could you spell that last name for us?
My last name is Jordan, Jordan. Hers is Zin.
Z-I-N?
Man.
Zimmerman, thank you, all right. And is the state ready to proceed?
Yes.
All right, and I see you had a document, what document did you have?
We have a written statement of appearance for you.
That would assist us, let me let you approach with that. Thank you. And I'll come back to housekeeping matters, but let me go to the defense. Is the defense ready to proceed?
Yes, Your Honor. Nicholas Steverson for the defense, along with my co-counsel, John Harrison. We also have written entries of appearance if you would like.
That would assist, yes, thank you. I'll let you approach as well.
Thank you, Your Honor.
Thank you. All right, the first thing I'd like to do, first thing I've confirmed the defense is ready to proceed. I'd like to move to any housekeeping matters. We'll move to motions in limine after that. But let me begin with the state. Any preliminary matters on behalf of the state or housekeeping matters first?
Yes, Your Honor.
All right, and Ms. Zinman, go ahead.
First, we wanted to ask, may we refer to you as judge and jury?
At this point, I would have you consider the bench being the jury as well. So yes, we'll be the ruling panel and ruling judge, but also the jury in the case.
Okay. May we consider ourselves constructively approached on objections, or would you like us to actually approach the bench?
Constructive approach would be the best. So anytime we're having an argument, we'll presume it's outside the presence of the jury, but you wouldn't have to actually approach.
Okay. And may the witnesses be constructively sworn in?
All right. I think that's the best approach unless there's an objection. Witnesses will be constructively sworn in, so I won't have them sworn in with each witness.
We wanted to stipulate that the dates as listed in the problem have been moved up 13 years. So what is listed in the problem, the burglary took place in 2006. That will now be 2019, coming to trial in 2020. Additionally, we wanted to stipulate that the days of the week will be the same as listed in the problem. So if it says a Thursday in the problem, it'll be a Thursday constructively in 2020.
All right. And does the defense agree to that stipulation as well?
Yes, Your Honor, we do.
I will accept that. And so I take it any evidentiary materials will update the dates by 13 years as well.
Yes, Your Honor.
All right. All right. Any other housekeeping matters?
Yes, the parties have stipulated to the admissibility of exhibits A, B, and D.
All right. And I want to verify, people have different expectations with that. My understanding from what you've said is that you've agreed that they're admissible, they'll still be offered and admitted, but at this point, there's no objection to their admission once they're moved. Is that correct?
Yes, Your Honor.
I'll accept that. All right?
And finally, the parties have stipulated that the sworn testimony of an unavailable witness, Joy Walford, as inadmissible.
All right. And I should check with both of those stipulations that A, B, and D are admissible, but also Ms. Walford's testimony is not admissible. Is that the defense agreement as well?
Yes, Your Honor, it is.
All right. Any other preliminary matters?
No, Your Honor.
Did the defense have any housekeeping or preliminary matters?
Yes, Your Honor. We would like permission to constructively sequester the witnesses and to constructively have the defendant sitting at counsel table.
All right. Any objection?
No, Your Honor.
All right. So witnesses will be sequestered with the exception of the defendant, who is presumptively at the table, even though a physical person may not be there.
Yes, sir. We would like permission to move about the well during openings and closings.
Generally, that's acceptable. The one thing I'll say, and it's deceptive, if you're standing in what we would call the well, we can see you from about your shoulders up. So if there's a demonstration or something, it may be better to be behind that. But if you're no more than about 2 or 3 feet from the bench, if you'd like to move about in front of the podium and the tables, both sides may do that as well.
Understood. We'd like to ask Your Honor's preferences for where we should deliver our directs and openings from.
My preference is that you're within an arm's length of the podium. I am not particularly wed to you being in front or behind, except that given this particular layout, in all honesty, it's probably better if you are behind the podium, but you can be to either side.
Okay. And lastly, what's your preferences for timekeeping?
We have a separate timekeeper, and so we'll allow her to keep time, and we'll check in with her as appropriate.
Okay. And then one final stipulation. The parties have agreed that the defendant's 2015 domestic violence felony is inadmissible.
And is that correct for the prosecution?
Yes, Your Honor.
I'll accept that stipulation.
No further housekeeping motions from the defense at this time, Your Honor.
All right. Are we ready to proceed to motions in limine?
Yes, Your Honor.
Let me begin with the state. Mr. Jordan, when you're ready, go ahead.
Your Honor, the people would move to have the reason for the defendant's termination admissible. For context, he was terminated by his supervisor under the accusation of stealing beer and drinking in a back room while on the job, and it alleges that he had done so at least 3 times over approximately a 1-month period before his termination. The defendant will attempt to explain a fingerprint that was found on a package of candy inside the victim's home by claiming it was placed there while he was performing his duties. It was purchased from that same grocery store. The people would like to use this evidence to show that the defendant was not the model employee that he will claim to be, and that he was not performing his duties as they were intended to be performed. The defendant's duties as a supervisor made his actual stocking duties a relatively small part of his work, and this evidence would help the jury determine the credibility of his testimony as to the likelihood of his fingerprint having made it onto that package, as it gives them additional information about the caliber of his performance on the job. This should be outside the scope of the 404B1 exclusion because we're not alleging that this affected his behavior in a particular occasion. We are offering it as evidence of his work habits and his performance as a stock supervisor. This evidence goes to the defendant's credibility if and when he alleges that the fingerprint on the package was placed there during the course of his work, not for his propensity for any given action outside of his performance. Under 608B, this will provide insight on the truthfulness of the characters of the testimony of this witness, and should be admissible against the defendant if he gives a statement that his work performance was adequate or above adequate. Additionally, or in the alternative, the people would like to use it as evidence of a habit or routine under Rule 406. That habit or routine being that the defendant was not consistently performing his work duties, but was habitually or routinely either stealing from his employer or drinking beer in a back room, or both.
All right. I may have some follow-up, but I'll go to the defense. Your response in terms of the motion.
Yes, Your Honor. Second? There it goes. The defense thinks that the reason for the defendant's termination is inadmissible under 401, 403, and 404B1. Firstly, the reason that he was terminated is not relevant to any facts at issue here today. The fact that he was terminated and that he was terminated for cause may go to his intent because he didn't have money after that job, but it doesn't go to any other facts at issue. Even if it does, even if it is relevant under 401, it's unfairly prejudicial to introduce evidence that he was fired for stealing. For more context, the defendant also specifically contends that his supervisor made up that reason to fire him because the two had a disagreement. Lastly, I believe that this is improper character evidence under 404B1. While the prosecution said that they're going to introduce evidence that as evidence that the defendant was not performing his job duties, I think that what it's really falling under is that he has a propensity for stealing, and that's, of course, inadmissible under 404B1.
And why would propensity for stealing be an issue in the case?
Because the charges at issue today are grand theft and burglary. So, any evidence that the defendant had a propensity in the past for stealing from his employer is inadmissible to prove that he did in fact steal on the specific occasion at issue.
I understand. Any reply?
The people maintain that as to the 401 challenge, we find that this is relevant because the explanation that the defendant is going to give is that he put his fingerprint on there in the course of his performance, and this does help the jury to evaluate the likelihood of that. Knowing how consistently and how appropriately he was performing his job goes directly to the likelihood of that fact being either true or untrue. As to the relevance, we feel that it's a highly relevant fact because it, basically for the same reason. It speaks to what type of an employee he was and whether or not he was actually performing this duty. As I mentioned, he was the stock supervisor, so this was a relatively small portion of what he did on the job. And having a pattern of not doing doing what he's supposed to be doing in his employment is highly relevant to evaluating that fact. As to the 404B1 hearsay, we are not using this evidence, or we do not plan to use this evidence to say that it is more likely or less likely that he actually committed this offense. We are just trying to use it to say, to speak to the likelihood of whether or not he was actually performing his duties on the job.
How is that latter not directly propensity evidence of saying he was a bad employee and he got fired for drinking and stealing, which would suggest that his character is a bad employee, meaning he would be less likely to do his stalking duty, in other words, acting in conformity with his bad character as a poor employee. In other words, not to the general theft, but how are we not using a propensity evidence to say he got fired for drinking, which would show he probably wasn't stalking because he's a bad employee?
The defendant hasn't pointed to a particular instance where this fingerprint would have been left. He's using it as kind of a general, at some point in his employment, he believes that he left this fingerprint. So it wouldn't be pointing to any specific occasion or any specific instance in his employment.
All right. I'll do all the rulings together, but Mr. Jordan, any other motions limiting by the prosecution?
Yes, Your Honor. The people would like to present evidence of the defendant's prior conviction for burglary. For context, and I do apologize for not mentioning this at the beginning of the motions, Your Honor. The defendant is accused of stealing cash, jewelry, and silverware during a burglary of the victim, Elsie Stevens' home. And his prior conviction for burglary actually occurred at the same building complex as the victim lives. While it does fall under a 404B, we would like to use it to show that the defendant had knowledge of the building where the crime was committed, and specifically how to stealthily enter a unit in that building, and how to avoid making the same mistake as he did the last time. We know that this evidence would need to pass a Rule 609B, as it is more than 10 years old. His conviction is 15 years old. The people's position is that the probative value of the previous conviction is substantially outweighs its prejudicial effect. Having broken into the same building before shows that he has knowledge of the layout, how to maneuver the building, obviously how to break into a unit there, and what the security of the building may be like, particularly because the victim moved into this same building 15 years ago, so it was at the same time as his previous conviction, meaning her home is likely very similar to the one he previously burgled. One of the important facts of this case is that the burglar was able to enter the condo without being seen by anyone other than Ms. Stevens, and to do so, leaving only one usable fingerprint. The defendant having previous knowledge of the building and what to do or to not do while he was burglarizing at it is an important fact that the jury should be able to consider. It passes a 403 test as well because the probative value of it is very significant, such that it substantially outweighs any prejudicial effect. The evidence is not to tie the defendant's character to burglary necessarily, or to suggest that he is more likely to be a burglar in general. We would like to use it to simply show that he knows how to break into a unit at this specific location, and that he has experience that would make him better at doing so.
For the defense, your response.
Yes, Your Honor. While I understand the prosecution's position under 404b2, none of the witnesses who will testify today have personal knowledge that the two condominium complexes are in fact the same. If my client chooses to testify, I expect he'll testify that he has been told that Ms. Stevens complex is, the Stevens complex is the complex that was previously broken, that he had previously broken into. However, he does not know that, so it's knowledge based on hearsay, which is of course inadmissible to prove that the two are in fact the same. I have the line from Mr. Grubb's deposition. If I can read it aloud, I think that might help. I'm on page 30 of the deposition of Tony Grubb. That 2005 burglary occurred in the same condominium complex where Ms. Stevens lives now. Isn't that correct? Answer, that's what I've been told. I don't really know for sure since I did not break into Ms. Stevens' condo. Since the only witness who has any knowledge that the two condominium complexes are in fact the same has only knowledge that's based on hearsay, I don't believe that there's any grounds under 404b2 to present the two condominium complexes as the same, and thus present that the defendant had prior knowledge under 404b2.
All right. Mr. Stevenson, excuse me. Mr. Steverson, is Steverson or Steverson?
Steverson. Your Honor.
Mr. Steverson, I apologize. I want to come back. Mr. Jordan, any final reply?
The defendant will hear testimony today from Ms. Stevens as to where she lives, and of course he knows what the location that he was previously convicted of burglarizing is. So even if he may have only heard it in passing before, he will definitely have knowledge of the location he's being accused of burglaring today.
And is there some unique characteristic of this particular apartment complex that the jury could say, well, being able to break into one unit would give him insider knowledge opposed to just being generally as a burglar breaking into apartments, that somehow it would give him unique knowledge on how to break into Ms. Stevenson's apartment?
May I have just a moment to confer with co-counsel?
Your Honor, may I briefly add to my response?
Yes.
I'd also like to point out there, while Mr. Grubb may have known the address of the burglary he was convicted in at some point, that conviction record isn't available to us. Moreover, we know nothing about the condominium complex. Condominiums are sprawling suburban, things. They don't necessarily have the same layouts. They don't necessarily have the same buildings or doors or entries. As such, breaking into one condo in that complex isn't necessarily the same as breaking into another one.
All right. Mr. Jordan, go ahead.
Well, our position is that since the condo is in the exact same complex, in fact, the same building, we believe that a knowledge of the layout of the building is very useful in breaking into any given unit inside of it. Simply the fact that he's already been there and he's already successfully made his way inside of a building or inside of a unit in that building makes it, it's a probative fact to help the jury evaluate whether or not he would have the kind of skills that were necessary to enter this unit, and to do so without being caught in the same way that he was before.
All right. And I just want to verify, was the state planning to bring this in through any witness other than Mr. Grubb? In other words, we're simply asking for permission to ask Mr. Grubb about it.
I would have to confer with my co-counsel momentarily. So. It would just be from Mr. Grubb.
Right. And I just want to verify one last thing. You said that this was a conviction within 10 years. Is that correct?
It is slightly outside of it. Well, 15 years ago.
15
to be
all right.
precise. Yeah.
All right. Any other motions in limine by the people or by the state?
No, Your Honor.
Any motions in limine by the defense?
Yes, Your Honor. The defense moves pursuant to 802, 701, and 702 to exclude Exhibit C from evidence. For a bit of context, this exhibit is a jewelry appraisal for a necklace which the state alleges the defendant stole. However, the exhibit's an out-of-court statement, which the defense anticipates the state will offer to prove the value of the necklace, which of course is impermissible under 802, unless it falls under a hearsay exception, which the defense believes it does not. And the alternative, jewelry appraisal, is a set of highly specialized technical knowledge within the scope of 702. However, we have no idea whether the person who made this opinion of the jewelry's value had that set of technical knowledge, whether he based his opinion on sufficient facts or data, or whether he used and applied reliable principles to make an expert opinion of the necklace's value, as required by 702. Without that information, the defense moves to exclude the appraisal as impermissible lay testimony under 701.
The state's response.
As to the 701 and 702, this jewelry appraisal was made by someone whose occupation is appraising jewelry. It's something that they do on a regular basis. It's how they earn their living. We believe that they would qualify as an expert to give this kind of opinion. And as to the 801 hearsay challenges, 801 and 802 hearsay challenges, we believe that this would fall under the 803.5 exception for a recorded recollection. It is a matter that the witness, the jewelry appraiser, knew about. I'm sorry. I am on the wrong page here. We believe that it is an exception that falls under the 803.6 records and regularly conducted activities exception. It was Ms. Stevens' practice to have her jewelry appraised. She did it at or near the time the information was transmitted by someone with the knowledge. She personally went and had her jewelry appraised. The record was kept in the course of a regularly conducted activity of a business. The jewelry appraiser obviously is regularly appraising jewelry. Ms. Stevens made it a practice to keep her jewelry appraised. Making the record was a regular practice of that activity. She has a record of her jewelry, and all of the conditions are shown by a qualified witness. We believe that Ms. Stevens counts as a qualified witness because she makes a practice of having her jewelry appraised. She was present when it was appraised, and she knows the techniques that the jewelry appraiser must have used. She was there.
All right. Any reply by the defense?
Yes, Your Honor. I'll start with the 701 challenge and then work back to the hearsay challenge.
All right.
Even if this appraiser had a business under appraising jewelry and would satisfy that part of 702, we haven't seen any evidence that he used sufficient facts or data to actually make this opinion. We have no idea whether he just made an opinion based on what Ms. Stevens told him about the necklace or Googled it. There's no facts or data that will be able to be introduced to show that this is a reliable expert opinion under 702. As to the hearsay exception under 803.6, we believe, firstly, that Ms. Stevens is not a custodian as required by the rule. Custodian generally refers to business custodian, record keeper. Ms. Stevens is not that, whether she commissioned the appraisal or not. Moreover, Ms. Stevens doesn't have personal knowledge of this particular appraisal business or the appraisal industry in general. Even if she sometimes had her jewelry appraised, she's not a member of that industry qualified to speak on its record-keeping practices.
All right. And then any other additional motions eliminated by the defense?
Yes, Your Honor. The defense moves to exclude Exhibit F from evidence pursuant to 802 and 404B. This motion is related to the prosecution's motion to introduce evidence regarding Mr. Grubb's termination from his job. Exhibit F is an employee incident report written by the defendant's previous employer about the defendant regarding his termination, which the defendant refused to sign because he contends it was false, that the statement written on the termination sheet was false. As the supervisor's out-of-court statement, this exhibit is hearsay and does not fall in any of the hearsay exceptions, so should be excluded for that reason. And the alternative, it's also should be excluded under 404B1 as evidence of prior bad acts.
All right. And Mr. Jordan, the state's response.
As I mentioned, the state would like to use portions of that the information from that exhibit, and we believe that it does fall under the exception to the 404B1. May I have just a moment?
Yes.
To confer with my co-counsel.
Looks like it's on now.
All right. We think that it falls under an exception to the 404B1 because we are not using it to present evidence of his character or his propensity to burgle in general. We are specifically seeking to use the information from it to attest to his knowledge of this specific location. As I had already mentioned, this is this. Doing the right one. We are specifically looking to use this information to shed light on his character for dishonesty. The events that surround his termination are relevant if the defendant attempts to bring in facts about his employment, if he tries to allege that he is a good employee, as I mentioned. We think that this fact would be highly pertinent for the jury to be able to consider in evaluating the truthfulness of that statement and any mischaracterization that he may make about it.
All right, and then finally, defense reply in light of that argument.
Yes, Your Honor. I believe that using this evidence as, his propensity for lying in a situation to evaluate his credibility today is exactly what 404A1 is designed to prevent. This is character evidence, pure and simple. As to the prosecution's earlier contention that the reasons that he's fired are somehow relevant to anything in this case, I think that we could get there by just saying he was fired and fired for cause. Saying that he was fired for cause means that he wasn't necessarily performing his job duties in the way that his supervisor wanted him to, without the risk of unfair prejudice under 403. That would be a compromise that I would be happy with.
At this point, I don't want to stretch this out too far since we're on the mock trial competition and not the motion eliminate competition. It's well argued. I'll make some fast rulings. First, as to the reason for termination, the stealing the beer or drinking is charged, I'm going to overrule the request to allow that, sustain the defense objection to that information. I do think in terms of the fingerprints on the candy, it requires a propensity or character connection to show if he's a bad employee in one area, perhaps he wasn't doing his stalking job. It's actually in candor, not a strong association in any event, and the risk of unfair prejudice is exceptionally high. As to habit or routine practice, it would have to be more in terms of establishing he acted in a particular way because he always does that, suggesting that he was always drinking or that he was always stealing because he was fired one time for that. I don't think we fall into a habit. And I think the risk, as I've indicated, of a jury saying at this point he was fired for stealing, so he sounds like he must be a thief, is exceptionally high risk. So the risk of unfair prejudice greatly outweighs what I think the probative value would be. So I'll sustain under 403 and 404. As to the prior conviction for the burglary, we're a little bit outside the normal Rule 609 range, 15 years instead of 10. But what I am hearing is that there's possible probative value in that Mr. Grubb knows the rooms and the layout of the apartments, that he has the ability and he knows how to get into the apartments in a way as having demonstrated it, having done that in the past. As long as the foundation's laid in that regard, I'm going to deny the request to preclude that and eliminate at this point. And as long as other information comes at the time, I would allow testimony in terms of the prior conviction, primarily to show under Rule 404 that he would have knowledge and not to show propensity for breaking in, with a limiting instruction to the jury as well. As for the jewelry appraisal, I'm less concerned about the hearsay issue. I think at this point, as long as I believe as Ms. Stevenson can lay the foundation as to how it was taken, how she got that, we're likely to fall under an 803.6 exception for regularly conducted activity. And although she's not a custodian of the records, since she was the customer and can describe how it was kept and what the business was, I think we're likely to get past that hurdle. The bigger issue is the one raised by the defense of, is this truly a 701 opinion, or do we have sufficient basis for this jewelry store to be able to make an opinion as to the value of the property? It's a close call, but for purposes of today's proceedings, I'm going to overrule the objection. I think there's sufficient basis to say that a jewelry store that is in the business of appraising jewelry, there's probative value in that regard, and by preponderance of the evidence, it would be admissible, which is the grounds for admissibility. But I will sustain the defense objection to Exhibit F itself, first because I'm sustaining the contents, the objection under 404, but secondly, I don't think we've got a business record exception or regularly conducted activity, and that firing someone is not a regular practice of the business, and it's the regularity under 8036 that gives us the circumstantial guarantee of trustworthiness, not simply that a record was kept the one or two times it's happened, but that it's done over and over and so forth. So it's a long way of saying, at this point, I'm blocking and granting the motion lest circumstances change as to the reason for the termination in Exhibit F, but I am not precluding at this point the testimony regarding the prior burglary in the case or the jewelry appraisal. Having said that, unless the parties have a different issue, are you ready to proceed with the trial itself?
Yes, Your Honor.
Yes, Your Honor, the defense is ready.
All right, let's begin with the opening statements, and we'll begin with the state's opening statement. Is the state ready to give its opening statement?
Yes, Your Honor.
All right, let me get everything set. Looks like we've got our notes. When you're ready, you may proceed then.
Mr. Grubb was out of money, out of options, and today he's out of luck. It's July 1st, 2019, in the middle of the night. Miss Elsie Stevens, a 78-year-old woman, is asleep in her bed after a quiet night at home. Suddenly, she's awoken by the sound of her sliding glass door opening. She waits, listening for more sounds. The shape of a man appears in her bedroom doorway. Before she has a chance to scream, he flips on the lights. He points something at her. It's shiny, silver. Without her glasses on, she thinks it's a gun. Terrified for her life, she complies with his demands. First, he demands that she show him her jewelry. She shows him her jewelry box. He plunges his hand in and takes out as much of it as he can. Specifically, he takes from her a gold necklace with unique links, a special favorite of Miss Stevens. Next, he demands all of her cash. She gives him everything she has, but that's still not enough. Finally, he takes her set of real silverware. It's a family heirloom, her last remaining link to her late sister. She begs him not to take it, but he takes it anyway. When he goes into the kitchen to get a bag for the silver, he has the audacity to take a Hershey's chocolate bar from a package in her refrigerator. He eats it in front of her as he stuffs her precious silverware into a grocery bag. Before he leaves, he tells her that if she calls the police, he'll come back later and hurt her. Finally, he leaves. Miss Stevens is left alone, terrified, crying at her kitchen table, devastated that her sister's silver is gone. Good evening, ladies and gentlemen of the jury. My name is Abby Zinman, and this is my co-counsel, Mr. Rami Jordan. We represent the state of Lone Star in today's case against Mr. Tony Grubb. The state of Lone Star has charged Mr. Grubb with burglary, with assault or battery, and grand theft. It is our burden today to prove to you, beyond a reasonable doubt, that Mr. Grubb is guilty of these crimes. What we show you today will make your job easy, to find Mr. Grubb guilty on both counts. Today, you will hear from Miss Stevens, a kind, church-going elderly woman. She'll tell you about the night that her condo was robbed, about how she lives alone, about how she feared for her life. You'll also hear from Detective Dale McIntyre, the lead detective on Miss Stevens' case. He'll tell you about a fingerprint that was found on the package of Hershey bars from Miss Stevens' refrigerator, the same package from which the burglar took a candy bar. Detective McIntyre will tell you about how that fingerprint has been positively identified as belonging to the defendant, Mr. Grubb. Detective McIntyre will also tell you about the gold necklace that was taken from Miss Stevens. He'll tell you that when the necklace was finally located, it had been pawned just 2 weeks after the robbery by, again, none other than Mr. Grubb. Today you'll also hear from Miss Selena Hardaway, Mr. Grubb's girlfriend. She'll try to tell you that there's no way that Tony could have done this, that he was asleep in bed next to her the entire night. But evidence will show that there is serious doubt as to whether she would have woken up when Tony crept out of the room. If he chooses to testify today, you'll also hear from Mr. Grubb himself. He'll try to tell you that all of this is just an unlucky coincidence, that he was just in the wrong place at the wrong time. But the truth is that in July of 2019, Mr. Grubb had just been fired from his job. He was out of money. He was out of options to make it to the end of the month. Around the same time, he came into possession of a gold necklace. In fact, the very same gold necklace that had been stolen from Miss Stevens. Mr. Grubb will testify that he didn't even have possession of that necklace until July 6th. His girlfriend will testify that he gave it to her before the 4th of July. Mr. Grubb will testify that he won that necklace playing a game of pool. His girlfriend will testify that he found it on the ground in a parking lot. Whatever the true story may be, know that not all of the testimony you hear today can possibly be true. It is your job as the jury to determine what you find credible and what you believe to be the truth. At the end of today's testimony, my co-counsel, Mr. Rami Jordan, will stand before you and explain the law. He will explain to you that we have a burden to prove to you today. We must prove to you, beyond a reasonable doubt, that Mr. Grubb is guilty of burglary with assault or battery and grand theft. Mr. Jordan will summarize the testimony you've heard and the evidence you've seen and will prove to you that we have met our burden today. He will ask you to hold Mr. Grubb accountable for his selfish crime. He will ask that you find Mr. Grubb guilty of burglary with assault or battery and grand theft. In July of 2019, Mr. Grubb was out of money and out of options, but today he's out of luck.
Ms. Zimmerman, thank you. The defense like to give an opening statement at this time. Mr. Harrison, when you're ready, you may proceed.
Not investigated, not proven, not guilty. My name is John Harrison, and together with my co-counsel, Mr. Nicholas Steverson, I represent Tony Grubb today. On the night of July 1st, 2019, a small family settled down for a night in together. Tony Grubb, his girlfriend, Selena Hardaway, and her 2 children cherished times like these when they could laugh, relax, grow closer together as a family. Like most hardworking folks, their life had its ups and downs. Mr. Grubb had recently lost his job where he worked in the stockroom at a local grocery store. He and Ms. Hardaway worried about how to maintain a sense of normalcy for the kids. It was a stressful time. But in that stressful time, Mr. Grubb looked to his loved ones, like his family, for comfort. Just a couple of weeks later, Mr. Grubb and Ms. Hardaway would hear every parent's worst nightmare. One of the kids had fallen extremely ill. The cost of the child's care was high, and Mr. Grubb took a gold necklace that he had won in a game of pool down to the pawn shop and sold it to raise funds for the child's care. One day, suddenly, the police showed up at the house. They asked Mr. Grubb questions about places he didn't know, people he'd never met, things he'd never done. They hauled him away. I wish I could tell you that that was the only tragic story that you'd hear today. But before you hear the story of Tony Grubb, you'll hear about Ms. Elsie Stevens. On a fateful night in July, a man broke into her home, threatened her, robbed her. It was a terrible thing to happen to someone. And what's worse, she wasn't wearing her glasses that night. She couldn't definitively identify the face of her attacker, point the police in his direction, and say, "Go get that man." And speaking of the police, you'll hear about their investigation of this incident today. You'll hear from a man named Detective Dale McIntyre, the state's lead investigator in this case. And it's important that you listen closely to Detective McIntyre's testimony today. Listen for what he doesn't tell you. Listen for what he doesn't know about the events of July 1st. We anticipate the detective will tell you about a candy bar wrapper that was found in Ms. Stevens' home and about the one fingerprint that he found on that candy bar wrapper. Listen closely and hear that that was the only usable fingerprint collected from the scene. Listen closely and hear that no DNA evidence was collected. Listen closely and hear that they never found a gun at the scene. Listen closely and hear that that was the only usable forensic evidence collected from Ms. Stevens' home. Detective McIntyre's story will take him to a pawn shop, Lone Star Pawn. And you'll hear about a gold necklace he was looking for there, one that Ms. Stevens had originally purchased at a department store. Listen closely and hear that this gold necklace had no unique or definitive or identifying marks that could allow anyone to say for sure whose it was. And learn what you can from the detective about a man named Ace Hodges, a person of interest in his investigation. Now, it'll be tough to learn about Mr. Hodges from the detective. You won't hear about his interview of Mr. Hodges. You won't hear about how he found Mr. Hodges. Listen closely and hear that this man was never interviewed, that this man has still not been found. Towards the end of his investigation, Detective McIntyre showed Ms. Stevens a picture of a man, Tony Grubb. He asked her if this was the man who had robbed her. She didn't say yes. She wasn't sure. After you've heard all of this testimony today, the state will stand up here and ask you to pin all of this on Mr. Grubb. Now, the state's burden today is to prove guilt beyond a reasonable doubt. And yet, when you've heard their story, when you've listened closely to the testimony, you will have substantial reasons to doubt the story they tell you. At that time, my co-counsel, Mr. Steverson, will stand before you. He'll walk you through the state's argument. He'll point out all the flaws, all the holes, all of the unconnected dots that led to the tragic choice to charge Mr. Grubb with these crimes. He will remind you that this matter was never fully investigated. He will show you just why the state has not proven their burden. And he will ask you to return a verdict of not guilty.
Thank you. All right, we'll move to the next stage of the trial, which is the presentation of the evidence, beginning with the state's case in chief. Is the state ready to call its first witness?
Yes, Your Honor. The state calls Dale McIntyre.
All right. Mr. McIntyre, if I can have you take, wherever we have the witness stand, right here, or we'll have you take the witness stand. At this point, you're constructively sworn, so I won't swear you back in, but if I could have you begin by stating and spelling your name, please.
Dale McIntyre. DaleMcIntyre.
Mr. McIntyre, thank you very much. And Mr. Jordan, when you're ready, you may inquire.
Yes, Your Honor. Sir, could you tell us why you're here today?
I was the lead investigator of the burglary of Miss Elsie Stevens.
And what is your occupation, sir?
I'm a detective with the Harris County Sheriff's Office.
And how long have you been in law enforcement?
About 20 years.
And how long have you been a detective, sir?
Going on 4 years. I was promoted in 2016.
What kind of cases do you investigate?
Any kind of cases that is assigned to me except homicide.
You mentioned you're the lead detective on the burglary of Elsie Stevens' condo. I'd like to ask you some questions about that case. First, what is the address of her condo?
17783 Jamestown Way.
And what city is that?
Armadillo, State of Lone Star.
What is the county?
Harris County.
Did your investigation identify a suspect?
Not initially.
Did your did that at some point change?
Yes, once we had some evidence that connected an individual suspect with the evidence collected at the scene, we were able to identify an individual.
Has that suspect been charged with a crime?
Yes, he was charged with burglary with assault and grand theft.
Can you tell me the name of that suspect?
Tony Grubb.
And is he here today?
Yes, he is.
Could you identify him by an article of clothing?
Yes, he's wearing a somewhat bluish sweater and a blue button down.
Would the record show that Detective McIntyre has correctly identified the defendant, Tony Grubb?
For record, he's described the defendant's clothing, and you may proceed.
Can you tell me how you became involved in this investigation?
I was randomly assigned to Ms. Stevens' case per our departmental procedures, and the case came onto our department after an initial 911 call on the night of July 1st of this past year.
And when did you take over the case?
That following morning.
I'd like to ask you about that first day of your investigation. What was the first step you took?
I initially went on, sort of debriefed the crime scene investigators at the scene, and then followed on to corroborate with everything I had been informed of with Miss Stevens and asked her to retell me her account of the story.
What did you do in response to that conversation with Ms. Stevens?
I collected all the evidence, I gathered all the evidence that had been collected by the crime scene investigators and proceeded to have it tested for any fingerprints or anything that we could identify.
Can you describe these items for me?
Yes, a chocolate wrapper was collected along with a flashlight.
Do you recall the brand of chocolate?
I believe it was Hershey's, if I'm not mistaken.
Permission to retrieve my notebook.
You may.
Showing opposing counsel what has been marked Exhibit B. Permission to approach the witness with the same for purposes of identification.
You may.
Do you recognize that?
Yes, this appears to be the chocolate wrappers I just mentioned that we had collected from the scene.
Does it appear to be in the same or substantially the same condition as the last time you saw it?
It does.
You mentioned that you collected this evidence because you were informed that the crime scene investigators were interested in it. Could you tell me a little bit more about that? Why were they interested in it?
We had found a individual's fingerprint that did not belong to Miss Elsie Stevens.
Do you know what the CSI team did with it?
Yes, it was tested by our lab, and no initial match was found.
And I'd like to ask you a little bit more about the burglary itself. What items were taken?
Ms. Stevens had reported a specific amount of cash along with a unique jewelry she valued very much, along with some other less valuable jewelry, and finally her prized silverware collection.
What action did you take when you learned these items had been stolen?
I proceeded to essentially test out or feel out the local pawn shops, since we expected that items of these qualities and nature would be pawned.
Did you interview anyone else at Elsie's condo, Elsie Stevens' condo?
Yes, that morning when I was there, I interviewed her neighbors to see if anybody had seen anything, but nobody had seen anything that night.
When did you get a lead in your investigation?
It wasn't until about July 19th where we got a notice from a local pawn shop, I believe it was Lone Star Pawn, that one of the items that we were looking for had popped up.
Let's talk about that. What item did you hear had been spotted?
I made my way to the pawn shop, and the pawn shop owner produced a necklace that matched the description of Miss Stevens' stolen necklace.
What did you do after you saw the necklace?
I inspected it. It essentially matched the characteristics that we were looking for, and I asked for any documentation that went with it, and the pawn shop owner offered up the pawn shop ticket.
Showing opposing counsel what's been marked Exhibit D. Permission to approach the witness with the same?
You may.
Do you recognize that?
I do. This is the accompanying pawn shop ticket that came with the necklace that was reported.
Does it appear to be in the same or substantially the same condition as the last time you saw it?
It does.
Is there a signature on that pawn ticket?
There is.
Can you read it?
Tony Grubb.
At this time, the people would like to enter Exhibit D into evidence, Your Honor, and have it constructively published to the jury.
All right. My understanding is there was a stipulation that D was admissible, so D is admitted at this time. You may show it to the jury constructively.
At this time, the people would like to enter Exhibit B into evidence and constructively have that published to the jury.
All right. The same standard B is also stipulated as admissible, so B is admitted, and you may also show that to the jury constructively.
Yes, Your Honor. What did you do with this pawn ticket after you collected it?
I collected both the pawn ticket and the necklace, and after this I wanted to confirm my suspicions that this was in fact the stolen necklace from Miss Stevens, so I made my way towards Miss Stevens to have her corroborate or identify the necklace.
Was she able to do that?
Yes, she was. She pointed to the unique links that make up the necklace in order to recognize it and confirm that it was her stolen necklace.
Showing opposing counsel what's been marked Exhibit A. Permission to approach the witness with the same?
You may.
Do you recognize that?
Yes, this appears to be a picture of the stolen necklace.
Is it a fair and accurate picture of that necklace?
I would agree.
What did you do? At this time, the people would like to enter Exhibit A into evidence, Your Honor, and have it constructively published to the jury.
All right. Since A is also stipulated to be admissible, Exhibit A is also admitted, and you may constructively show it to the jury.
Yes, Your Honor. Were you able to connect the pawn ticket to a suspect?
Once Miss Stevens had confirmed that this was in fact the necklace that was stolen from her, I proceeded to have the lab back in the department, run a check on the name on the accompanying pawn ticket, Mr. Tony Grubb, to see if anything popped up. And it turned out that we did have some prints on file for this individual, and then we were able to match those prints to the fingerprint found on the Hershey's chocolate bar wrapper.
How did you proceed with your investigation at that point?
I proceeded to procure an arrest warrant and a search warrant for Mr. Grubb and his home.
What did you want to find in his home?
We were hoping to find any further connections or any of the items that were stolen or anything connecting Mr. Grubb to the robbery.
Did you find any of those items there?
We did not.
Did you question Mr. Grubb about the burglary?
I did immediately following his arrest.
I'd like to ask you some questions about that interview. How did it begin?
I read Mr. Grubb his rights and then proceeded to inquire about the necklace and how that came into his possession, along with whether he knew anything about Ms. Stevens' burglary.
How did he respond about the burglary?
He denied any knowledge of it.
And how did he respond about the necklace?
He said he had won it at a wager at a local pool bar or pub, if I'm not mistaken, against a Mr. Ace Hodges is the name he said.
Did he tell you when this occurred?
Yes, he said this was on July 6th, according to his responses.
Did Mr. Grubb explain how his fingerprints came to be inside Miss Stevens' condo?
No, he was unable to offer that explanation.
Mr. Grubb claims to have received the necklace from this Ace. Let's talk about him. Did you attempt to find him?
We did. After Mr. Grubb's interview or questioning, he immediately became a person of interest in the case, and we proceeded to find out that Ace was just a nickname. His actual name was Virgil Hodges, and we exhausted all our resources, did our best to go through national databases to try and find out more about this man, and asked for the help and assistance of the state troopers, but were unable to locate him.
Was Ms. Stevens asked to identify the burglar?
Yes, I compiled a photo packet of about six men, including a picture of the defendant, Mr. Grubb, and Ace Hodges, and she was able to narrow down to those two individuals.
What physical evidence have you found that implicates Mr. Hodges?
None whatsoever.
I have no further questions for you at this time.
Is there any cross-examination?
Yes, Your Honor. Detective McIntyre, let's begin by talking about your job for a little bit. You've only been a detective for 4 years.
Just about, yeah.
You're not a specialist in investigating burglaries.
No, as I mentioned, our department assigns cases at random aside from homicide.
Detective, a yes or no answer will do in the future. You work on whichever sort of case you get assigned to.
Correct.
You don't have a particular specialization as a detective at all.
As I just mentioned, no.
Detective, I'd like to now discuss what you were doing on the night of the break-in. You were not personally at the crime scene that night?
No, the overnight officers were.
You weren't there when they dusted for fingerprints?
No, our criminal scene investigators were.
You weren't there when they took pictures of the crime scene?
Once again, no.
You weren't there when they collected the evidence?
No, our criminal scene investigators were.
You didn't personally interview Ms. Stevens that night?
I did the following morning, not that evening.
So that's a no, you did not personally interview her that night?
No.
Detective, now that we've talked about what you were doing on July 1st, let's walk through the evidence that they collected from the house. The crime lab collected a Hershey bar package?
Correct?
They didn't collect a gun?
No.
They collected a flashlight?
Correct?
There were no usable prints on the flashlight?
Correct?
They didn't collect any DNA evidence?
No, none was found in the crime scene.
They didn't collect any other forensic evidence?
Aside from the fingerprint that was found in the Hershey's chocolate bar, no.
Now that we've discussed the evidence that you had, Let's talk about your trip to the pawn shop. You got a break in your investigation?
Yes, this was on July 19th.
A necklace had been received at Lone Star Pawn.
Yes, that's the note we received.
It appeared to you to match the description provided by Ms. Stevens?
Initially, yes.
The necklace was gold.
Correct.
It was made with a particular pattern to the links.
That's what Ms. Stevens identified with, yes.
There was no pendant on the necklace?
No.
There was no locket on the necklace?
No.
There was no engraving on the necklace?
Correct.
There were no particular signs of wear, scratches or dings on the necklace?
Not that I could tell.
There was no definitive identifying mark on the necklace?
Aside from the unique links to which Ms. Stevens pointed at, no.
Detective, let's talk about Mr. Grubb. You showed Ms. Stevens a picture of Mr. Grubb.
Correct.
Ms. Stevens could not identify Mr. Grubb as the intruder.
She was able to narrow it down from a collection of 6 images.
Detective, the question I asked was Ms. Stevens could not identify Mr. Grubb as the intruder. Is that correct?
Not definitively correct.
You arrested Mr. Grubb.
Yes, after we procured his warrant.
You searched his home.
Correct.
You didn't find the silver there?
No, we did not.
You didn't find the jewelry there?
Not, none of the other jewelry that Ms. Stevens had reported, no.
You never found the silver?
Not so far, no.
You never found any of the other jewelry?
Not so far, no.
You didn't find anything belonging to Ms. Stevens in Mr. Grubb's home?
Correct.
You interviewed Mr. Grubb after you arrested him?
Yes,
You asked him about the necklace?
I did.
You wanted to give him a pool against Ace Hodges?
That's what he claimed.
You never interviewed Ace Hodges?
We weren't able to locate him.
The Lone Star State Troopers searched for him?
Yes, they did.
They didn't find him?
Correct.
You checked a couple national databases looking for him?
Yes, we did exhaust all our resources.
You couldn't locate him?
Correct.
Your department hasn't been able to find Ace Hodges since July.
As I just said, we've been unable to locate him.
Now, Detective, I'd like to ask you something about a question you answered for Mr. Jordan. It was your testimony today that Ms. Stevens was able to narrow down from 6 pictures, was able to say that it was one of the 2?
She was able to narrow down who she believed her assailant was to those 2 images. Correct.
Detective, you gave a deposition in this matter?
I recall.
I was there? You were there?
Correct.
You took an oath to tell the truth during your deposition.
Yes.
You understood it was important to tell the truth during your deposition.
Correct.
You signed your deposition.
Correct.
Showing opposing counsel Detective McIntyre's deposition. Permission to approach a witness for impeachment?
You may.
Now, Detective, I'd like you to look here at the second question up from the bottom on page 25 of your deposition. And I'm going to read along out loud, and I'd like you to read along silently with me.
Okay.
After you arrested Tony Grubb, did you ever ask Ms. Stevens if she could identify him? Answer, yes. I prepared a photo pack with 6 photos. I included both Tony Grubb and Ace Hodges, along with 4 others. I showed the photo pack to Ms. Stevens, but she could not identify her attacker. Did I read that correctly, Detective?
Correct.
No further questions at this time.
Thank you. Was there any redirect examination?
May I have just a moment to confer with my co-counsel, Your Honor?
You may. When you're ready, you may proceed.
Yes, Your Honor. What is your role on this case?
I'm the lead investigator on Miss Stevens' burglary.
Have you interviewed her as part of this case?
I have several
Objection
times.
asked and answered. The counsel asked this question during his direct examination.
And your response is to, you've already asked these questions.
Withdrawn, Your Honor.
All right, I'll let you withdraw that. You may ask a different question.
Have you spoken with Ms. Stevens regularly?
I'm sorry, can you rephrase the question?
Have you spoken with Ms. Stevens?
Since I was assigned to
Objection
her case,
asked and
yes.
answered.
And your response.
Withdrawn, Your Honor.
All right, you may withdraw the question. You may ask-
Motion to strike the witness's partial answer.
All right, the jury would disregard the last answer of the witness. You may ask a new question.
No. I'd like to ask you about some of the physical evidence in this case. As part of your investigation, was any evidence found in Ms. Stevens' condo that implicated anyone?
Yes, the physical evidence collected, we were able to tie it to one individual and one individual only, and that is the defendant, Mr. Grubb.
No further questions, Your Honor.
And I've forgotten, does the state of Lone Star traditionally allow recross when appropriate? I've heard a no, so at that point, Detective, thank you very much. You're free to step down. Thank you. That'll work. Is the state ready to call its next witness?
Yes, Your Honor.
You may proceed.
The state calls Miss Elsie Stevens to the stand.
Stevens, if I can have you come up to the witness stand as well. And you've previously been constructively sworn in, so I won't swear you in again. But if you'll take that microphone, and if I can have you begin by stating and spelling your name, please.
Elsie Stevens.
I think it just got turned off.
Oh, did I turn it off? Oh.
That's on.
Elsie Stevens, Stevens.
Stevens, thank you. And Ms. Zimmerman, when you're ready, you may proceed.
Good evening, Miss Stevens. I understand that some of the events that we're talking about today may be difficult for you to recount, so I really appreciate you being here today to give your testimony. How old are you, Miss Stevens?
I'm 79 years old.
Where do you live?
I live at 17883 Jamestown Way, Armadillo, in Harris County.
Does anyone else live there with you?
No, I live alone.
So I'd like to talk a little bit about the events of July 1st, 2019. Do you recall July 1st, 2019?
Yes, that was the date of the break-in into my condo.
So let's back up a little bit first. Did you go anywhere that evening before the break-in?
I went to the grocery store that afternoon.
What did you do when you got home?
I unpacked my groceries, and then I cooked dinner, and then I watched a little TV.
Did you speak to anyone else that evening?
I did. I talked to my neighbor Bob about a ride to church the next day. We sometimes ride together.
Then what happened?
And then I went to bed around 10:45.
Now, I know this may be a bit difficult to talk about, but what happened after you went to sleep?
Well, I was woken up by what sounded like the sliding door of my living room opening.
What did you do?
I laid there for a little bit and listened, and it sounded like someone was in my apartment, but before I could do anything, someone was standing in my doorway.
Can you describe that person?
It was a man. It was a 6-foot-tall, white, muscular, 225 pounds.
Objection, speculation.
Your response.
The witness is testifying to her personal experience as to what she saw as far as the man. I fail to see how this is speculation.
Any reply?
Yes, Your Honor. As to the man's exact weight and exact height, I don't believe that any layperson would be able to look at a person and say that person weighs 225 pounds exactly.
I'm going to overrule on speculation, allow that to be a subject of cross-examination, but you may proceed.
So, can you describe the man?
He was a tall, 6 foot tall, 225 pound white man.
Was he wearing a mask?
No, he wasn't.
What did the man do?
He flipped on the light and he pointed something at me and he told me not to make any noise.
Could you tell what he was pointing at you?
I couldn't make out what it was, but it was protruding and it was shiny and I thought it was a gun.
Did he say anything to you?
Objection calls for hearsay.
In responses to hearsay.
I believe ample evidence has been provided that this is an opposing party statement.
All right,
Consider the
any
testimony.
reply?
Your Honor, I don't believe that any evidence has been provided that this is an opposing party statement. All we've seen is that this is a tall white man.
All right. That's the subject matter of the case. Let me ask, just for an offer of proof, what is it you believe that the witness will say the man said?
Maybe constructively approach.
Yes.
I believe she'll say, he told me not to get up and that if I helped him, I would not be hurt.
All right. I guess I should come to the defense. How is that to prove the truth of the matter asserted, since it doesn't, I'm not hearing an assertion in that it's a command or a directive to what to do, wouldn't be true or false? How would it be hearsay?
Your Honor, if that's what the witness expects, if that's what the prosecution expects the witness will testify to, I agree that that's a threat or a statement, or
It's
not a statement.
It's a good point at this point. I don't know that we have foundation to establish it was a party opponent. It's simply an individual. But since I think what I'm hearing based on the offer of proof is it wouldn't be an assertion to prove the truth of that assertion, I'll overrule as to hearsay and let you ask the question. I'll let you finish your answer.
Did he say anything else to you?
He told me not to make any noise and to get up and help him and I wouldn't be hurt.
What happened next?
Well, I got up and helped him and he told me to show him where my jewelry was.
Did you show him your jewelry?
Yes.
Did he take any of your jewelry?
Yes, he shoved as much as he could into his pockets.
What happened after he took your jewelry?
And then he asked me if I had any money in the house.
Did you have any money in your house?
I had about $40 in my wallet.
Did he take it?
Yes, he did.
Was he still holding the shiny silver object at this point?
Yes, he was like waving it around.
What happened after he took your money?
He then asked me if I had any silver in the house.
What did you do?
Well, I didn't want him to take it because it was the last remaining heirloom that I had of my sister, but I showed it to him.
What did he do after you showed him the silver?
He asked me if I had a bag,
And then what happened?
and then I told him I had a bag in the kitchen, grocery bags, and he went into the kitchen to get one.
Did he do anything odd while he was in the kitchen?
Yes, he opened up my refrigerator, and I had a package of Hershey's bars in the fridge, and he took one.
What did he do after he took the Hershey bar?
He then came back to shove the silver into the bag, and he ate the Hershey bar.
And what happened after that?
And then he told me not to call the police or he would come back and hurt me, and he took the silver and he left.
What did you do after he left?
Well, I sat down at my dining room table and I cried. I couldn't believe that my sister's silverware was gone.
And what did you do next?
Well, then I got mad, so I called the police.
What happened when the police came?
Well, they closed off my condo and they brought those CSI people in, and then they asked me a bunch of questions.
Did they ask you about anything in particular that they found in your home?
They asked me about a flashlight that was on my dining room table.
Was it your flashlight?
It was not my flashlight.
Did you notice anything else the police did in your condo?
They took the bag of Hershey's, the package of Hershey's in the fridge, and then they asked me to give them a list of the things that had been stolen.
Is there anything in particular that was missing?
Yes, this necklace that I had, this gold rope necklace with these individual links, that was taken.
Now showing opposing counsel what has been entered into evidence as Exhibit A. Permission to approach the witness with the same.
You may.
Do you recognize this photograph?
Yes, this is my necklace that was stolen.
So I'd like to ask you a little bit about the specifics of some of the items that were taken. Do you happen to know the value of the silver that was stolen from you?
Objection calls for speculation.
Any response?
It's her silverware. Additionally, I don't actually expect the witness to testify to an exact value of the silver.
Right, and we would do this outside the presence of the jury. What are you anticipating she will say?
I am anticipating she'll say that she does not know the exact value of the silverware.
All right. Given that, any response?
No, Your Honor, I withdraw my objection.
All right. You may ask the question.
Ms. Stevens, do you know the value of the silver that was stolen?
I don't know the value of the silver, but it was real silver.
Do you know the value of the necklace that was stolen?
Yes.
Objection calls for speculation.
I'll let the last answer stand, but are you planning to ask her what that value was?
Your Honor, I am planning to lay foundation for the entrance of Exhibit C into evidence.
All right. At this point, I find the objections, although wise and prudent, a little premature. The question was if she knew. She's indicated yes. She hasn't gone into what that value is. And given your offer that she'll be laying more foundation as to the basis of her knowledge, I'll let you lay that foundation. We'll come back to the substantive objection.
Ms. Stevens, do you know the value of the necklace that was stolen?
Yes, I had it appraised a few years ago.
Did you have the appraisal done by a professional jewelry appraiser?
I did.
Did that appraiser create a record of the appraisal at the time you had it done?
Yes, he did.
Are you generally familiar with the appraisal?
Yes, he walked me through it.
And do you own a lot of valuable jewelry?
I do, but after my husband passed, I put most of my valuable jewelry in a safety deposit box, and I don't keep it at the condo. But I do have nice pieces at my condo.
Showing opposing counsel what has been marked as Exhibit C.
All right.
Permission to approach the witness with the same.
You may.
Do you recognize this document?
Yes, this is the appraisal.
Is it in the same or substantially the same condition as when you last saw it?
Yes, it is.
Now move to enter Exhibit C into evidence.
Any objection to Exhibit C?
Yes, Your Honor, I would renew my hearsay objection from motions to eliminate. I don't believe that the witness has laid foundation that making the record was a regular practice of this particular business, or that she would necessarily have that knowledge. I would also renew my 701 objection that we haven't seen testimony that this is made using reliable facts or data.
First, your responses to the foundation for the 803.6 exception.
Yes, Your Honor. We have established that the record was made at or near the time of the information being transmitted. It's from a professional jewelry appraiser. I believe it's a reasonable inference that as part of the jewelry appraising business, this kind of record would be kept and was a regular practice of that business. I don't believe it requires the testimony of an expert to speak to that. I believe it's a reasonable inference, and additionally, I believe that we have laid foundation that she's a qualified witness. She owns quite a bit of valuable jewelry as she's testified. She's testified that she's familiar with the appraisal process.
All right. And then as to the 701 objection, any additional testimony in terms of that this is not a lay opinion and is an expert opinion?
Your Honor, we are not attempting to claim that that Ms. Stevens is an expert in jewelry. We are simply having her identify her own jewelry appraisal.
But I guess the argument is that the jewelry appraiser, in this case, I think it's the jewelry judge, would be offering an expert opinion based on specialized knowledge and training and experience.
Your Honor, we're not testifying as to the expert witness status of the jewelry judge. We're simply establishing that the jewelry judge is in the profession of jewelry appraisal and that this type of record is regularly kept and maintained as part of that business.
And I guess my concern is if this was, for instance, they said, well, it was an employee there who'd never done an appraisal, didn't have any training, and just took a shot in the dark, it wouldn't be admissible. Why should this opinion be admissible? That this is a trustworthy valuation of the actual price of the jewelry?
Again, Your Honor, this is a professional jewelry appraiser, as Ms. Stevens has testified. This is a person who does this as a living. I can't speak as to who the exact employee was at this appraiser's office, but I can speak to the fact that this is their profession. This is what this person does. It's not somebody off the street offering an opinion on the value of this jewelry.
And let me ask a mock trial question, not a real-life question. Are there facts in this case that would go to further foundation of this expert's ability or this appraiser's ability to appraise jewelry?
No, Your Honor.
I want to come back. Any reply to the objection?
Your Honor, while we may not know, or while we may know that the jewelry judge is not just some person on the street, it may just be some jewelry shop in a shopping mall. Like, we don't know that this is actually a professional appraisal, how reliable it is, whether they put any sort of facts or data into making their evaluation, or they just looked at it and said, oh, that's probably worth about this.
I think it's an excellent objection. For mock trial purposes, though, I think that the little I know about the problem, I think that's probably the basis of getting the evaluation and the elements in. So I'm going to overrule the objection for purposes of today's proceeding, but it's the right argument for both of you. Objections overruled for purposes of today's trial. Exhibit C is admitted.
Move to enter Exhibit C into evidence.
It is admitted, yes.
How much does the appraisal say your necklace is worth, Ms. Stevens?
It says $375.
So I'd like to ask you a bit of an odd question, Ms. Stevens, but did you give this man permission to come into your home on the night of July 1st, 2019?
No, I did not.
Were you scared when the man was in your condo?
I was absolutely terrified. This man is in my apartment with what I think is a gun and takes my sister's silver.
No further questions at this time.
Any cross-examination?
Yes, Your Honor.
Permission to retrieve the exhibits from the witness?
You may, unless, Mr. Stevenson, were you planning on using any of those exhibits?
Your Honor, I'll briefly use Exhibit C, but I have a copy if Ms. Inman wants to retrieve hers.
All right.
Good evening, Ms. Stevens. I'd like to just start off asking a few questions about your memory of July 1st. You normally wear glasses.
I do.
You're wearing glasses today.
I am.
You can't see well without your glasses.
I can't.
You were awakened on July 1st,
I was.
but you didn't put on your glasses.
No.
The stranger flipped on your lights,
Yes.
and your eyes had a hard time adjusting to the light.
They did.
You never put on your glasses while the stranger was in your home.
No, I wasn't able to.
So, no, you never put them on.
No.
You couldn't make out the features of the stranger's face.
I could make out his shape. I could make out his body.
And I apologize if my question was confusing. Specifically talking about his face, you couldn't make out any features of his face.
I couldn't make out specific facial features of his face.
So, no, you couldn't make out any facial features.
No.
The man was holding a shiny item,
Yes.
but you couldn't see what that item was.
I thought it was a gun.
But you couldn't say for certain what it was.
No, I guess not.
You thought the man had dark blonde or light brown hair,
I did.
but you can't say which.
No.
The robber wasn't wearing a mask.
No, he wasn't.
Was he wearing gloves?
I don't recall.
The man went into your refrigerator while he was at your apartment.
Yes.
You didn't open the refrigerator for him.
No.
He opened your refrigerator.
Yes.
You were terrified the man would come back and hurt you if you called the police.
He said if I called the police, he would come back and hurt me.
And the man also said that he knew you lived alone.
Objection. Hearsay.
Any response?
Your Honor, I believe I can lay up a little bit more foundation for excited utterance.
All right. I'll let you withdraw the question, and if you'd like, you can lay additional foundation.
Yeah. So, the burglary was very tense.
Could you repeat that?
The burglary was very scary.
Of course.
The burglar was very upset with you.
He was forceful.
Well, at one point you pretended you didn't own silverware.
I didn't want him to take my sister's silverware.
Yeah. So you pretended you didn't own silverware.
Yes.
And when you pretended you didn't own silverware, the man got upset with you.
Yes, he wanted me to show him.
And he pointed a shiny item at you.
Yes.
He pointed a shiny item at you several times throughout the night.
Yes, he was waving it around.
Before he left, he pointed a shiny item at you again.
I don't recall.
Okay. So now that we've talked about your memory of July 1st, let's turn to your role in the police investigation. The police came to your apartment the night of the robbery,
Yes, I called them.
and they came.
Yes.
They sealed your apartment off.
Yes.
They dusted all over the place.
Yes, they left a big mess.
Yeah. And you believe that they were dusting for fingerprints.
Objection calls for speculation.
Any response?
Your Honor, anybody who's seen CSI knows what dusting for fingerprints looks like. This is also Miss Stevens' home. She's watching the police work as it's happening.
All right. At this point, I would think it wouldn't be speculation. I think it's a 701 opinion in terms of describing based on her rationally based perceptions. I'd allow you to follow up on redirect, but the objection's overruled. You may ask the question.
Ms. Stevens, I'll repeat my question. They dusted all over the place for fingerprints,
I guess they could have been dusting for fingerprints.
but they left dust all over your apartment,
Yes, it was a big mess.
including the door to your fridge,
I don't know.
but all over your apartment.
Yes.
The police called you a few weeks after the incident.
They did.
They asked you to look at photographs of potential suspects.
They did.
They showed you 6 photographs.
They did.
You weren't able to identify anyone in those photographs,
I was able to narrow it down to 2 people.
but you weren't able to say for certain that the man in any of those photographs was the man who robbed you.
I was able to narrow it down to 2 people.
But you weren't able to say for certain that one of the men was the man who robbed you.
I couldn't definitively pick out one of the 2 people that I narrowed it down to, yes.
So, no, you weren't able to say for certain.
No.
Now, you wouldn't be able to identify the robber's face if you saw it again.
I most likely not, no.
You wouldn't be able to identify the robber if he was here today.
I could identify someone who resembled the robber, most likely.
But his face specifically, you wouldn't be able to identify the robber's face if he was here today.
No, like we already discussed, I couldn't pick out his specific facial features.
So my question was, if you saw the robber's face today, in this courtroom, you would not be able to identify his face.
Most likely, no.
Most likely not, or no?
Probably not.
Ms. Stevens, let's take a quick break from all that awfulness and talk about you and your habits. You shop at Albertsons.
I do.
The Albertsons on Memorial Road.
Yep.
You always do your grocery shopping at that store.
That's where I grocery shop.
At that store.
Yes, at Albertsons.
And you buy your chocolate bars at that store.
That's where I bought those chocolate bars, yes.
So you bought some of those chocolate bars on July 1st.
Yes.
The stranger stole one of the chocolate bars that you bought on July 1st.
He did.
You have a safety deposit box
I do.
at a bank,
Yes.
and you keep all your valuable jewelry in that safety deposit box.
My most valuable jewelry in that safety deposit box.
So yes, you keep your most valuable jewelry in that safety deposit box.
Yes.
Ms. Stevens, I'd like to talk about the items allegedly taken from your apartment. Let's start with the necklace. You testified today that the stranger took a gold necklace from you on July 1st.
Yes.
You bought that necklace from the Marshall Fields in Chicago.
Yes.
Marshall Fields is a department store.
Yes.
Your necklace didn't have any identifying marks on it.
It had unique links.
So there are no identifying marks, though, on it.
I don't understand the question.
Was there anything like a pendant on the necklace?
No.
Or a locket with your picture in it?
No.
Or anything else that would make you certain that it was yours?
Other than the fact that it was a unique necklace and I got compliments on it wherever I wore it.
So a unique necklace that you bought at a department store.
Yes.
The police recovered a necklace.
They did.
That necklace appeared to be your missing necklace.
That necklace was my missing necklace.
But neither necklace had any pendants on them
No, the necklace didn't have a pendant.
or a locket.
Objection asked and answered.
Any response? Go ahead.
I'm asking specifically about the necklace that the police bought. Earlier I was asking about the necklace that Ms. Stevens had before the robbery.
It's getting close. I don't think it's become unduly cumulative under 403, so I'd allow you a final time to do that. You may proceed.
Yes, Your Honor. Ms. Stevens, I'll repeat my question. Neither necklace had any identifying feature besides the links.
Yes.
So you testified that you had your necklace appraised,
I did.
and that appraisal was done in 2017,
Yes.
3 years ago.
Yes,
You've worn the necklace since the appraisal.
I did. I get compliments on it whenever I wear it.
Has it been damaged since the appraisal?
No, not to my knowledge.
You don't know for certain if the appraisal is still accurate,
I would think it would be accurate.
but you don't know for certain.
Objection calls for speculation.
Help me with that. How would she be speculating as to what she knows?
How would she know for certain if the appraisal is accurate? It's, as previously testified, she's not claiming to be an expert in jewelry. He's asking her opinion on whether an appraisal would be accurate.
Any response?
Your Honor, this came in under 8036. If she's the custodian of this record, she should know whether it's still accurate, whether it's still good, or if it's outdated.
And since the specific question is whether or not she knew if it was accurate, I think she can indicate whether or not she believes or knows that it is or it isn't. I'll overrule as to speculation. You may ask the question.
Ms. Stevens, I'll repeat my question. You don't know for certain if the appraisal is still accurate,
I guess not, but I think it would be.
but you don't know for certain.
I guess not.
You haven't had the necklace appraised since 2017,
No,
and your necklace was machine made.
I don't know.
Showing opposing counsel, it's been previously marked as and admitted as Exhibit C. Permission to approach with the same.
You may.
Ms. Stevens, I've just handed you what's been previously admitted as Exhibit C. Based on this exhibit, was your necklace machine made?
Yes, it was.
Now that we've talked about your Marshall Fields necklace, let's talk about your other items. You gave the man less than $40.
Yes.
You have no idea what the value of your stolen silverware is,
No, but it was real.
but you have no idea what it was worth.
No.
You never had your silverware appraised.
No.
You showed your silverware to many of your neighbors,
My neighbors knew I had the silverware.
and you showed it to them.
I don't recall.
You had some of your neighbors over for dinner,
Yes.
and at those dinner parties, you showed them the silverware.
They saw the silverware at my dinner parties, yes.
So many of your neighbors had seen the silverware.
Yes.
Your grandniece, Joy Walford, knew about your silverware.
Sweet joy.
Is that a yes?
Yes.
The silverware originally belonged to your sister,
Yes, it did.
Joy Walford's grandmother.
Yes.
Joy Walford wanted your sister's silverware.
Objection calls for speculation.
Your response.
Your Honor, if I may approach and give an offer of proof.
You may.
I believe that the witness will testify that her and Miss Walford had a big fight over the silverware, and that it was the subject of a will dispute. That's not speculative. This is within the witness's personal knowledge that she had this fight.
All right. Ms. Inman, your response.
I don't believe foundation has been laid for how Ms. Stevens would know what was in her grandniece's mind. I believe it's calling for speculation.
I'm going to overrule as to speculation. I'll allow you to follow up on redirect if you think there's missing foundation as well or a lack of a basis for weight. If the objection's overruled, you may ask the question.
Ms. Stevens, Joy Walford wanted your sister's silverware.
Yes, she did.
You and her had a big fight over that silverware.
Yes, we had a disagreement over the silverware.
You had a big fight over that silverware.
Yes, we had a fight over the silverware.
Because Joy felt that she should have been left it in the will, in your sister's will.
Objection calls for speculation.
All right. Your response.
Your Honor, again, this is the subject of a will dispute between these two women. Miss Stevens should know what that will dispute was about. She was involved in it.
All right. And your reply.
There's no evidence that there was a will dispute. There's nothing presented today that there was any dispute over the will, and I don't believe there is evidence that there was a will dispute available. I believe that Ms. Stevens could testify as to the fact that there was an argument, but I don't think that she could testify as to her grandniece's feelings about the silver.
All right. It's less an issue of speculation. It overlaps with that and more in terms of information based on hearsay. The only way to know that is what the niece would have told her. But so far, since the witness has been able to describe this information rather than indicating she doesn't know or she's unaware, and since descriptions usually of mental states or desires would fall under an exception or 8033, I'm going to overrule us to that. If the witness doesn't know that information, she can certainly indicate as such, or if she would be guessing, she can say so. But presently, I'll let you ask the question. Objection's overruled.
Seems I forget where I was in my line of questioning. I apologize. Ms. Stevens, your sister's will left the silver to you.
It did.
And Ms. Walford believed that it should have been left to her.
I think she believed that should have been left the silverware, yes.
She wanted the silverware from you,
She did want the silverware, yes.
but you wouldn't give it to her.
No, it was left to me.
And because you wouldn't give it to her, the two of you had a big fight.
Yes, we had a fight.
Now that we've talked a bit about your missing silverware, let's talk about when Joy Walford lived with you. Ms. Walford lived in your condo at one point,
Yes, she did.
so she knew you lived alone.
Well, at the time, I didn't live alone.
But she knew when she moved out that you lived alone.
Yes.
She knew how to get into your apartment.
Yes, she lived there.
She knew where your sliding doors were.
Yes.
While she lived with you, Joy brought her boyfriend to your apartment,
She had a boyfriend while she lived with me, yes.
and she brought that boyfriend to your apartment.
I think he came over once or twice.
Well, you met him at your apartment.
I think so.
You think so, or you did?
I'm not sure. I think so.
Well, this boyfriend didn't go by his real name.
I don't remember his name.
You don't remember his real name.
No, I don't remember his name.
Well, you remember that he went by a nickname.
I remember he had a nickname. I don't remember what it was.
But you remember that it had something to do with playing cards.
Yes, it had something to do with cards.
So you remember that he went by a nickname that had something to do with playing cards.
Yes.
Now that we've talked about Joy and her boyfriend, let's return to the night of July 1st. The man wanted your silverware.
Yes, he wanted my silverware.
You pretended you didn't own any silverware.
I did not want him to take my silverware, no.
When he pretended you didn't own silverware, the man got upset,
Yes, he wanted me to show him the silverware.
and he pointed a shiny item at you.
Yes.
He told you he knew you had silverware.
Objection, hearsay.
Any response?
8032, Your Honor, excited utterance. We know that this man was upset that he wanted Ms. Stevens to give up her ruse, and as a result, under the stress of that excitement, he made this statement.
Your response, your reply.
I don't think this falls into the exception for excited utterance. I mean, the whole situation was certainly tense, but I don't think that this was a moment of particular excitement such that it would qualify as an excited utterance. It sounds like he was just threatening Ms. Stevens.
Right. I'll agree at this point. Excited utterance under 8032 has to be relating to a startling event. There's nothing startling here that would render his normal reflective processes to not be operative. He may have been angry, may have been upset, but I wouldn't classify it as an excited utterance. Was there an additional exception?
Your Honor, in that case, I'd ask that this comes in under effect on the listener, merely that the man told Ms. Stevens, I know you have silverware, and then as a result, Ms. Stevens gave up her ruse. It's about the effect that it has on Ms. Stevens and the action she took afterwards.
In response that it wouldn't come in for the hearsay purpose, but as to the effect on the listener.
A moment to confer with co-counsel, Your Honor.
Certainly.
Your Honor, may I briefly add
Yes.
to my argument? I believe prosecution also added that this is a threat. Threats are categorically not hearsay. If it's a threat, it should come in.
I'll let you respond to both of those issues.
Your Honor, as to the effect on the listener, I believe that generally at this time, Ms. Stevens has testified that she was complying with his demands because he was terrified. I don't believe that this particular statement had any further effect on her. I believe that she was just complying with his demands because she was scared the whole time. As to it being a threat, I fail to see how saying, I know you have silverware is a threat. It sounds to me like the man just said, I know you have silverware.
All right, and there are certain things, and I've touched on it, commands, questions, and so forth aren't assertions that are true or false. They can't be offered for the truth of the matter asserted normally. The statement, I know you have silver, the relevance appears to be that he would have actually known that fact. The effect on the listener seems minimal, if probative at all. And so at this point, it would seem to be coming in to prove the truth of the matter asserted as opposed to a different reason. I'd sustain also in terms of the objection on that basis as well. Unless there's a different exception, I'll let you go ahead and proceed, but move to a different question.
Yes, Your Honor. When he left, the man threatened you.
Yes, he told me if I called the police, he would come back and hurt me.
He also, when he said that threat, he also said he knew you lived alone.
Objection, hearsay.
Any response?
Again, Your Honor, I believe this is a threat that the man's saying he knew you lived alone, and as a result, that I'll come back and hurt you. It's not being offered for the truth of the matter asserted that the man actually did know she lived alone. Merely, it's just part of that threat.
I would agree that the threat of I will come back to hurt you wouldn't be offered to prove that he will come back to hurt you. That's the effect, that's the threat. The statement, I know that you live alone, though, I think falls more in the category of I know that you have silver, I know that you live alone. Its relevance really would be in the truth of the matter asserted. Objection sustained.
Yes, Your Honor. Ms. Stevens, you've never met Tony Grubb.
Not to my knowledge, no.
No further questions, Your Honor.
Any redirect examination?
Yes, Your Honor. So, Ms. Stevens, you previously testified, you said that your niece lived with you, correct?
Yes, Joy lived with me.
What was your relationship with your niece?
When we lived together, I had thought that she was over the fight. We lived well together.
Did she do anything to indicate that she was still upset about the silverware?
No, not at all.
I'd like to ask you a little bit more about the lineup of photographs that you were shown. Were you able to narrow down the set of photographs that you were shown?
Yes, I was able to narrow it down to 2 people.
If asked to identify somebody, would you be able to, based on, let me rephrase that question. Is there anyone here today that looks similar to the people that you saw in the photographs?
Yes, to the 2 people I narrowed it down to, it looks a lot like that man.
Right.
Objection. Speculation.
And tell me a little bit more about that. In terms of speculation, how is that speculation?
We've heard lengthy testimony from this witness that she didn't identify the man's face, that all she saw was his general build and that he was white. Pointing a finger at anybody in this courtroom and saying, hey, that man looks a lot like the person that I think that this robber was, because of that very narrow basis of reasoning, is purely speculative. We've heard that she couldn't identify the man's face. She looked around the courtroom and said she couldn't identify the man's face. If all she's going off of is his race and weight, I believe that's speculative.
Your response?
She was able to testify to the color of his hair, to his height, to his weight. I didn't ask her for certain to identify the person that robbed her. I said, is there anyone today that, in your opinion, looks similar to that person?
Your Honor, may I briefly respond?
You may.
I believe that that's purely speculative. Then if she cannot identify for certain who this man is, then she's by definition speculating about who it is.
We're a little off on speculation. I understand the basis of the objection. I am going to find that there's an insufficient foundation for her to identify a particular person in the courtroom, or say someone in the courtroom looks similar, given her prior identification, the grounds of simply knowing the height, the build, and due to the risk of unfair prejudice in 403, I'll sustain the objection. The jury would disregard that identification.
Yes. So that's been stricken from the record.
Exactly. That'll be stricken from the record. Objection sustained, and the jury will disregard. But with that, Ms. Inman, you may ask the next question.
So I'd like to ask you a little bit about some of the items that were taken from you. Your silverware that was taken, was it real silver?
Yes,
Question cumulative?
Any response? In other words, I think the objection is that this was gone into on direct examination. We're going to somewhere new.
I didn't ask her on direct examination if her silverware was real silver.
I remember the testimony that it was. I'll sustain at this point, unless we're going beyond just that it was real silver. I think we've elicited it. That's come out, so I would sustain as cumulative.
Okay, then I'll withdraw that question.
All right, I'll let you ask the next question.
So as to the necklace, the police came to your home. Did the police ask you to identify a necklace?
Objection cumulative, again.
Any response?
I didn't ask the witness this question on direct examination.
I'll give you a little leeway. I'll overrule at this point. Let you ask the question. We'll see where we're going.
Did the police ask you to identify a necklace?
When the necklace was stolen, I had to make a list of the things that were taken. And then when they found the necklace, yes.
So did the police ask you to identify the necklace as your own?
Yes.
And was it your necklace?
Yes, it was my necklace.
No further questions.
All right. Ms. Stevenson, thank you very much. Stevens, you're free to step down. Does the state have any additional witnesses?
No, Your Honor.
All right, does the state rest?
Yes, Your Honor, the state rests our case in chief.
All right. Any motions by the defense at this time?
Yes, Your Honor. The defense moves for a judgment of acquittal pursuant to Federal Rules of Criminal Procedure 29. The prosecution has not introduced evidence that, even viewed in the light most favorable to the state, could allow a reasonable jury to conclude that the defendant is the person who committed the crime. Today in court, Detective McIntyre was able to identify the defendant as the person he arrested, but as a logical proposition, this begs the question in terms of proving that the defendant is the person who committed the crime. Ms. Elsie Stevens, the lone eyewitness today, testified that the robber was standing in close proximity to her. Despite that, she was still unable to identify the defendant in particular as the man who robbed her. Additionally, in order to prove its charge of grand theft, the state must show that the value of the allegedly stolen items was between $300 and $5,000. The most recent valuation of the necklace is the $200 valuation from the pawn ticket, and this is the most reasonable estimate of the necklace's value, and thus the state has not proven that it can meet this element of grand theft.
And let me ask you, you mentioned the $200. I thought the exhibit said it was $375.
The most recent valuation would be the pawn ticket, Your Honor.
Oh, I see. All right, your response.
Yes, Your Honor.
Go ahead.
Your Honor, the standard for evaluating a Rule 29 motion is whether viewing all of the evidence in the light most favorable to the government, any rational jury could find the defendant guilty beyond a reasonable doubt. The state maintains that we have presented sufficient evidence that a rational jury could find the defendant guilty. Our witness has testified that an intruder entered and remained in her home without her permission, that he did so stealthily, and that the intruder made an intentional and unlawful entry. While he did so, he threatened her, and Ms. Stevens had a well-founded fear that he would commit an act of violence against her. This should be sufficient evidence to show all the elements of burglary with assault or battery to at least a degree that a rational jury could find the defendant guilty in a light most favorable to the government. Additionally, we've offered testimony and documentation that the defendant knowingly and unlawfully had possession of Ms. Stevens' property with the intent to deprive her of it and benefit himself. We've shown this by linking the defendant to the crime scene with physical evidence. His fingerprint was found inside of her home. And we've proved that he had the necklace stolen from her during the burglary. As my colleague on the other side said, he did benefit from it by pawning it for $200. The pawn ticket was signed by the defendant and includes his fingerprint on it. And the necklace was valued at $375 on an actual professional appraisal. I think it's fairly common knowledge that a pawn shop does not give you full value for the items that you bring in and sell to them. And in general, the price of gold trends up as the dollar goes down, so the value may very well have increased since that appraisal. In light of this evidence, the people oppose the motion for a judgment of acquittal.
All right. Any reply?
I would just note that the prosecution has introduced no evidence as to the fluctuations in the price of gold.
What I'll find at this point, you've both touched on it. The goal is at this point I need to look at the evidence in the light most favorable to the state, including any direct and circumstantial evidence, draw all reasonable inferences in favor of the state, and disregard contradictory evidence and not judge the credibility of the witnesses or the testimony or the weight to be given to them. In that situation, I think there's sufficient evidence that the jury could find, based on Mr. Grubb having pawned the item in question, indication that the owner had identified it correctly, and that there was a general matching in terms of the general characteristics of the person inside the home, and other evidence that he may have been in the home. I think there's sufficient basis to find that a reasonable jury could find, if they looked in the evidence in the light most favorable to the prosecution, identification had been proven. As to the value, although the pawn ticket had indicated $200, the jury doesn't have to follow the one contradictory piece of evidence and could find that the appraisal was the better estimate. And given that there's sufficient basis upon which it's possible to find beyond a reasonable doubt, the value is over $300. In light of that, I'll deny the motion for judgment of acquittal at this time. We will take a break, potentially, but then we'll come back and allow the defense to present any additional witnesses or testimony.
Yes, Your Honor. Yes,
I've assumed that you wanted a break, but did you want a break?
Yes, Your Honor.
All right, why don't we, I was going to ask, since we've been a little slow, somebody's been a little wordy on his rulings, let's take about a 5-minute break, and we'll come back in about 5 minutes. All right, thank you, and please be seated. All right, at this point, the prosecution has rested its case in chief. Does the defense wish to present any evidence in the case?
Yes, Your Honor. At this time, the defense would call Tony Grubb to the stand.
All right. In Colorado, we'd normally do what would be called a Curtis advisement in terms of his right to not testify. I'll assume we've done that, and Mr. Grubb has waived his right and is choosing and electing to testify. Mr. Grubb, is it Mr. Grubb for these proceedings?
Yes, Your Honor.
Mr. Grubb, if I can have you come up to the witness stand. And we'll pass you the microphone. Oh, thank you. That's right. And again, you've been constructively sworn in, so I'll just go to the testimony. If I could have you begin by stating and spelling your name, please.
Yes, Your Honor. My name is Tony Grubb, Tonygrub.
Mr. Grubb, thank you. And when you're ready, you may inquire.
Good afternoon, Mr. Grubb. I'd like to start by giving the jury a chance to get to know you. Where do you live, Mr. Grubb?
I live at 6734 12 Elks Boulevard in Armadillo in Lone Star.
And how long have you lived at that address?
I've lived there for 2 years.
Who do you live with?
I live with my girlfriend, Selena, and her 2 kids.
Are they your children?
No, they're not my kids, but they are basically in name. I mean, we're just one happy family. We're basically all together.
Now that we know a bit about you, let's turn to the events that we're here for today. Have you ever met Miss Stevens?
Not to my knowledge, no.
Who does Miss Stevens live with?
I have no idea.
Where does Miss Stevens live?
I have no idea.
Did you break into Miss Stevens' home on July 1st?
Absolutely not.
Did you steal anything from Miss Stevens on July 1st?
Absolutely not.
Did you steal anything from anyone on July 1st?
No, absolutely not.
Where were you on July 1st?
I was at home with the kids and Selena, and we went to bed in normal time.
And how do you know Selena was home with you?
I was with her the whole time, and we sleep in the same bed.
Now, we know that you were home on July 1st. Let's talk a bit more about the events of last summer. What did you do for work in June 2019?
I worked in the stockroom at Albertsons on Memorial.
And what did your work in the stockroom entail?
Oh, I was occasionally called to stock the shelves, so I would take things from the stockroom and put them physically on the shelf, so my hands are all over all the groceries in that store.
And when did you leave your job in the Albertsons stockroom?
I left at the end of June.
And how much did you work in the weeks leading up to leaving your job?
I worked there full time, so I worked 40 hours a week.
Showing opposing counsel what's been previously marked as Exhibit E. Permission to approach the witness with the time.
You may.
Mr. Grubb, I've just handed you what's been previously marked as Exhibit E. Do you recognize that document?
Yes, this is my paycheck.
And is this document in the same or substantially the same condition as last time you saw it?
Yes, it is.
At this time, the the defense would move to enter Exhibit E into evidence and publish to the jury.
Any objection to Exhibit E?
Yes, Your Honor. This evidence is hearsay.
Any response to hearsay?
Your Honor, will fall under 8036. I can lay more foundation if
All right.
necessary.
I'll let you lay additional foundation as the elements under 8036. So it's denied presently, but I'll let you lay more foundation.
Mr. Grubb. Where did you get this document from?
I got it from my employer at the Albertsons grocery store.
And did your employer generally issue documents like this?
Yeah, all the time to all the employees.
And how often did you get documents like this?
I got one every 2 weeks the whole time I worked there.
And this was issued to you specifically?
Yes, it has. Yes, it does. It was.
At this time, Your Honor, the defense would move to enter Exhibit E into evidence and publish to the jury.
All right. Any response in terms of 8036?
Yes, Your Honor. I don't believe that the defense has shown that Mr. Grubb is a qualified witness. He's not a custodian of this document. He's not the person conducting payroll for Albertsons. I fail to see how he's aware of how documents are kept for Albertsons or how he is a custodian of this document.
All right. And 8036 allows it to be a custodian or other qualified witness, since Mr. Grubb would have been the person who would regularly receive his paychecks. I think there's sufficient foundation to at least get past the requirement under 8036. I'll note the objection, but Exhibit E is admitted.
Mr. Grubb, how many hours are indicated on this pay stub that you worked in the weeks leading up to June 23rd?
One moment, please.
No worries. I can rephrase my question.
Oh, I see it. Yes, it is 40 hours
40 hours
per week, so it's 80 hours total in the weeks leading up.
Mr. Grubb, why did you leave your job?
Well, the supervisor had it out for me, so he made up a reason to fire me.
And what did you do after leaving your job at Albertsons?
I mean, I did what anyone would do, and I went and I looked for a new job.
And when did you find a new job?
Well, I found a new job. I mean, I didn't start till the end of July, but I did find a job shortly after.
Since we've talked about your new job, let's talk about a bit more about the rest of the summer. What did you do on July 6th?
On July 6th, I went to the Fulla Bowl pub, and I played pool like I do every Thursday.
Who did you play pool with?
It's just some friends, and then this guy came up, Ace Hodges came up and asked me if I wanted to play.
Objection, hearsay.
Any response?
Your Honor, asking somebody if they wanted to play is not a statement offered for the truth of the matter asserted. It's not hearsay.
I'll agree at this point. Asking if they want to play wouldn't be to prove that that was true or false, so I'll overrule as to hearsay. The answer stands. You may ask the next question.
Who's Ace Hodges?
I didn't know him. He was just some guy from around town, but I mean, till he got me into all this mess.
And what did you do in response to Ace wanting to play?
I mean, I said, sure, why not?
And who won when you played?
Well, Ace won the first 2 games.
Were there more games after that?
Yeah, I won the 3rd game.
What do you remember about the 3rd game?
Well, I remember winning. I was really happy that I won because he had asked if I wanted. He wanted to know if I wanted to. He was the one who placed the bet. We bet $50 on the 3rd game, and I was really excited for him to pay up. But when it came time for him to hand over the money, he didn't have it.
Just to clarify a little bit there, who wanted to bet on the 3rd game?
Ace wanted to bet on the 3rd game.
Objection, hearsay.
Any response?
Wanting to bet is not a statement, Your Honor. It's not offered for the truth of the matter asserted.
Let me ask if the question, if the statement was, I want to bet to prove that he was the one who wanted to bet, why would that not be to prove the truth of the matter asserted?
Your Honor, I guess I believe that there's no statement there. Who wanted to bet is not the statement I want to bet.
All right, any response?
I fail to see how Mr. Grubb could have known that Ace Hodges wanted to bet on the game unless Ace Hodges had verbally stated that he wanted to bet on the game. So I fail to see how foundation has been laid for how Mr. Grubb knew that Ace Hodges wanted to bet on the game.
All right. I think it's either coming in for the non-hearsay purpose of the request itself, or it would fall under 8033 in terms of his mental state, of his desire. I'm going to overrule as to hearsay. You may ask the question.
Who wanted to bet on the 3rd game?
Ace wanted to bet, and we agreed.
And what did you agree to bet on the 3rd game?
We agreed $50 is what he proposed.
And who won the 3rd game?
I did.
And what did Ace do when he won the 3rd game?
I mean, he didn't have the money. He didn't hand it over. All he had was this gold necklace that he gave me.
What was the gold necklace like?
It had some interesting links on it, but I mean, it was just a regular old gold necklace. I mean, I thought Selena would like it, if anything, so I took it.
So what happened when Ace offered you his necklace?
Objection, hearsay.
Your response.
What happened is the witness has already testified that this person offered him a necklace, and asking what happened, what did the defendant do in response is not a statement.
And as an offer of proof, is the witness going to testify as to what someone said or what someone did?
If I may constructively approach and
Yes.
give an offer of proof, I expect the witness will simply testify that in response, he agreed to take the necklace.
All right, I'll overrule as to hearsay. I think I see the potential concern or risk, but I'll overrule at this point, given that offer. You may answer the question.
What did you do when Ace offered you his necklace?
I mean, I was mad because I wanted the cash, but I took it.
And who did you think the necklace belonged to when Ace gave it to you?
Objection calls for speculation.
Your response.
This is asking for Mr. Grubb's thoughts. Mr. Grubb isn't speculating about his own thoughts. He can testify to his own thoughts and opinions.
Your reply.
He asked who he thought the necklace belonged to. That sounds like speculation to me.
All right. I think there's relevance in the belief, whether it's true or false, since he's asking what he thought. I don't think he's speculating as to his own belief. If we're trying to prove that that's who it belonged to, I'd want more foundation. But given the question, I'll overrule. You may ask the question.
Who did you believe the necklace belonged to when Ace gave it to you?
Definitely Ace Hodges.
Now that we know how he got Ace's necklace, I'd like to talk about what you did with Ace's necklace. You mentioned that you thought your girlfriend would like the necklace. Did you give it to her?
Yes, I did on our date night.
And what did she do with it?
She wore it for a while, and then we decided that it would be best if we pawned it.
Why did you decide that?
I mean, we needed the money. It was, we just had Selena's job until mine started at the end of July, so we thought it would be good to have a little extra cash around.
So what did you do?
I took it down to the pawn shop and I sold it.
And what did the necklace sell for?
I don't remember. It wasn't that much.
When you sold the necklace Ace gave you, did you believe it was rightfully yours?
Yeah, I won it fair and square.
Thank you, Mr. Grubb. No further questions at this time.
Any cross-examination?
Yes, Your Honor. Good evening, Mr. Grubb. So I want to talk to you a little bit about that necklace. You won the necklace playing pool against Ace Hodges.
Yes, I did.
Your girlfriend was not there when you won the necklace.
No, she was at home with the kids.
You told your girlfriend you found the necklace on the ground in the parking lot.
I didn't want her to worry, so yeah, I told her.
You lied to her about how you got the necklace.
Objection 403.
Any response?
He just testified that he told his girlfriend that he found the necklace on the ground in the parking lot and had previously testified that he won the necklace playing pool. So the only logical conclusion is that he lied to her about how he had gotten the necklace.
Mr. Severson, any response?
Yes, Your Honor. My objection is under 403 because I believe characterizing this as a lie from the get-go is unfairly prejudicial to the defendant. The defendant's already testified that he just simply didn't want his girlfriend to worry. I believe characterizing that as a lie is prejudicial, unfairly so.
All right. If it were closing argument, I might take a different position, but at this point, since you've asked the witness to verify, the witness can confirm or deny or characterize in that regard. I'm going to overrule on 403 basis. Allow you to ask the question, and you may answer.
You lied to your girlfriend about how you got the necklace.
I mean, I was trying to protect her, but I guess if you want to characterize it as that, then sure.
So to be clear, you lied to your girlfriend about how you got the necklace.
I guess so. Yes.
You did not want her to put an ad in the paper about the necklace.
No, I mean, I got it from Ace. I knew exactly where I got it from.
So to be clear, you did not want her to put an ad in the paper about the necklace.
No.
You did not want her to put up signs about the necklace.
No, I knew where I got it from. There was no need.
So just to be clear, you did not want her to put up signs about the necklace.
No.
You did not want to call attention to the fact that she had the necklace.
No, there was no need to put up signs because I had gotten the necklace from Ace.
But you didn't want to call attention to the fact that she had the necklace.
No, I just knew where I got it from. I didn't think there was any need for us to go to the effort.
So, Mr. Grubb, just to be clear for the record, your answer is no? You did not want to call attention to the fact that she had the necklace?
That's not the reason.
I'm sorry, Mr. Grubb, if my question was unclear, but for the record, I do need a yes or no answer. You did not want to call attention to the fact that she had the necklace.
No. No.
You won the necklace on July 6th, 2019,
Yes.
at the Full O Bowl pub.
Correct.
July 6th was a Thursday.
Yes.
You gave the necklace to your girlfriend the Monday after you won it,
Yeah, that was our date night.
which would be July 10th.
I think so.
July 10th comes 6 days after July 4th.
Objection, attorney testifying.
Going to overrule on that basis, I'll allow you to answer, if as long as that's foundational.
Yeah, that would make sense.
So, Mr. Grubb, I have a few questions about your personal history. You heard testimony today about where Miss Stevens lives.
Yeah, I remember them saying an address. I don't remember what it was, but yes.
But you did hear testimony as to where she lives.
Yes, I did.
And you live in Armadillo.
Yeah,
So you're familiar with the town of Armadillo.
yeah, as much as anyone who lives there.
You have been to the complex where Miss Stevens lives before July 1st, 2019.
At this time, Your Honor, I'm going to renew my 404B objection. I believe this is going to get into, if I may approach and give an offer of proof, I believe that this is going to the 2005 burglary conviction that we spoke of in motions in limine.
All right, I think there's potential relevance based on the testimony, especially in terms of the testimony of knowing where Ms. Stevens lived in the complex, and also I think for the prior grounds and basis, I think there's potential relevance in explaining how this individual may have been able to gain access. I'll note it's proper to preserve that issue, but at this point I'm going to persist in the prior pretrial ruling. Objections overruled. You may ask the question.
You have been to the complex where Miss Stevens lives prior to July 1st, 2019.
I don't recall.
You heard testimony today about where Miss Stevens lives.
Yeah, they mentioned an address. I don't remember what the address is or where that would be.
You have been to the complex where Miss Stevens said she lives.
Objection asked and answered.
Overruled at this point. I don't know that we've got a clear answer, but we can go too far. Objections overruled. You can answer the question.
I haven't been to Miss Stevens' apartment, if that's what you're asking.
No, that wasn't my question, Mr. Grubb. You said that you were familiar with the town of Armadillo. You said you heard testimony today about where Miss Stevens lives. My question is whether you have been to the complex where Miss Stevens lives prior to July 1st, 2019.
I don't think so.
A moment to confer with co-counsel, Your Honor.
You may.
So, Mr. Grubb, it's your testimony today that you have not been to the same complex where Miss Stevens lives.
I don't recognize the address.
You have been previously convicted of a burglary.
Objection, 404 and 609.
All right. I'll note the objection. It's overruled for the previously stated reasons. You may ask the question.
Mr. Grubb, you were previously convicted of a burglary.
It was a long time ago, but yes.
You were convicted of a burglary in the same apartment complex where Miss Stevens lives.
I mean, that's what I've been told, but I don't know.
So you have been to the complex where Miss Stevens lives prior to July 1st, 2019.
Your Honor, I'd renew my objection again under 404B2. Mr. Grubb just testified that he has no personal knowledge whether the condominium complexes are in fact the same. As such, I feel like this line of questioning is getting repetitive.
All right. Any response?
Your Honor, there's been testimony today from several witnesses about where Ms. Stevens lives. Mr. Grubb testified that he lives in Armadillo and is familiar with the town, and he just testified that he has been told that it was at the same, that his prior conviction for a burglary took place at the same apartment complex where Ms. Stevens lives. So necessary inference, I mean,
Your Honor.
it took place at the same apartment complex. He must have been there before July 1st, 2019.
Actually, I'm going to sustain the objection on different grounds. It's now asking him to agree to the conclusion. It's become argumentative. You've established the predicate facts that he's been told that's the same address. Getting him to agree to it is straight into argument, so I will sustain as argumentative. Let you go to a different question.
Your Honor, just to clarify, what am I not allowed to ask it?
The question that starts with the word "so" and then trying to get him to agree with your conclusion. So you have been there, I'll find as argumentative at that point.
You are aware that your prior conviction for a burglary was at the same apartment complex where Ms. Stevens lives.
Objection asked and answered.
I'll let you answer that question.
That's what they told me.
You have been inside a condo in that complex.
If it's the same one, then I guess so.
You're familiar with the layout of the complex.
I don't know if it's the same one. That's just what they told me.
Assuming that it is the same complex, you're familiar with the layout of the complex.
And calls for speculation.
I'll sustain also, it's asking her to agree to a conclusion. You can argue that to the jury in closing argument, but I'll sustain in terms of the question. Have you moved to a different question?
I'll move on.
Your Honor, in that case, the defense moves to strike the testimony about the conviction. We haven't seen any evidence that these condominium complexes are in fact the same, and as such, there's no use for the conviction under 404B2.
Well, given the representation by the witness that at this point she's been advised they were the same complex in the prior testimony, I don't think we can have it both ways of precluding her from her confirming it's the same one and saying because we've precluded that we can assume it's not. I'll note the objection. I'm going to overrule. I'll allow that prior testimony to stand, but I'll sustain as to asking her to agree to the conclusion and let you go to a different area.
So the complex where you were previously convicted of a burglary, you are familiar with the layout of that complex.
It was a long time ago. I guess if I was in that apartment. Could you repeat the question?
So the complex at which you were previously convicted of a burglary, you're familiar with the layout of that complex.
At least that one apartment.
And you're familiar with the security systems in that complex.
It was 15 years ago. I'm sure that it's changed.
But you were at one point familiar with the security systems of that complex.
15 years ago, but I guess.
Mr. Grubb, I apologize, but I do need a yes or no for the record. I apologize if my question was unclear. You were familiar with the security systems of that complex.
I was, yes.
You knew how to successfully break into a condo in that complex.
At the time, yes.
Now, Mr. Grubb, I'd like to ask you some questions about your work history. You used to be employed at a grocery store
Yes, I was.
until late June of 2019,
Yes.
just before July 1st, 2019.
Yeah, that sounds about right.
You were not supposed to start your new job until the end of July.
Correct.
You did not have any income for the month of July,
I mean, Selena was working.
but you personally did not have any income for the month of July.
No, I didn't.
Money was tight in July.
Yeah, we were getting by, but yes.
At this job, you were a stocking manager.
I worked in the stock room, yeah.
You only stocked when somebody called out sick.
That's what my job called me to do, yeah.
You were generally a good employee at this job,
I mean, I did my work.
but you were fired.
They made up a reason, but yeah, I was fired.
Objection, Your Honor. At this point, I'm going to go ahead and renew my the motion in limine from earlier. I believe that any reasoning regarding why Mr. Grubb was fired from his job was excluded from evidence.
Your response.
Your Honor, I wasn't going to ask about the reasons for which Mr. Grubb was fired, simply establishing that he was fired from the job.
All right. Particularly at this point, I had sustained in terms of going the grounds and bases. The defense asked on its direct examination as to why he left the job, given that it's opened the door somewhat to the reasons. But given the offer that you'll simply be going to the fact that it was a firing or termination, I'll let you ask that question. Objections overruled. You may proceed.
So let me just back up one question. You said you were generally a good employee at that job,
I thought I did fine.
but you were fired.
Yes, I was.
So I'd like to ask you just a little bit about your knowledge of Miss Stevens. You don't know Miss Stevens.
Not to my knowledge, no.
You've never been invited into her home?
Never.
You were not invited into her home on July 1st, 2019.
I wasn't at her home on July 1st.
You were not invited into her home on July 1st, 2019.
I wasn't there, so I couldn't have been.
Mr. Grubb, I would ask that you please answer the question that I'm asking. I apologize if it was unclear. You were not invited into her home on July 1st, 2019.
No, I guess I wasn't. No, I wasn't.
No further questions.
Any redirect?
Yes, Your Honor. Mr. Grubb, why did you tell Selena that you found the necklace?
I didn't want her to worry. I mean, I just wanted to protect her. I mean, I knew that she worries about money, and I didn't want her to worry that I was gambling it away.
And why were you not invited into Miss Stevens' home at any point?
I was never there.
Well, no further questions, Your Honor.
All right. In that case, thank you very much, Mr. Grubb. You may step down. If the defense is ready, you may call your next witness.
The defense calls Selena Hardaway to the stand.
Ms. Hardaway, if I can have you come up to the witness stand as well. You've also been constructively sworn, so I won't do that again. You've got the microphone. If I could have you begin by stating and spelling your name, please.
Selena Hardaway, Hardaway.
You may inquire.
Good evening, Ms. Hardaway. Let's begin with a few easy questions about yourself and your family. Where do you live?
I live at 6734 12 Oaks Boulevard in Armadillo, Lone Star.
Who do you live with?
I live with my 2 kids and my boyfriend, Tony Grubbs.
How long have you all lived there?
We've lived there, moved in with my boyfriend about a year and a half ago.
And what do you do for a living?
I am a nail tech at Design Hair Studio.
Ms. Hardaway, now, I'd like to talk to you about last summer. Did anything memorable happen last July?
Yes, my boyfriend, Tony, gave me a necklace.
When did he give it to you?
He gave it to me sometime around the 4th of July.
What did you do with this necklace?
Well, it was really pretty. It was really thoughtful of him to give it to me. But, you know, we had my youngest son, he's 6, so that was way more important.
What did you decide to do?
We decided to pawn the necklace. We just had so many expenses between prescriptions, ambient, other items and expenses that we had that we just needed to pawn the necklace in order to pay those expenses.
Can you describe what this necklace looks like?
It was just any other gold necklace.
Were there any markings on the necklace that would allow you to identify it?
No, I mean, there was nothing really, nothing different besides just being a gold necklace.
Showing opposing counsel what's been previously admitted as Exhibit A. Permission to approach the witness with the same?
You may.
Ms. Hardaway, I'm showing you what's previously been admitted as State's Exhibit A for identification. Do you recognize what's depicted in this photograph?
Well, I can tell that it's a gold necklace, and it looks similar in some ways to the one that Tony gave me, but I can't say for certain that it's the same necklace.
Now let's move on and discuss July 1st of last year. Do you remember where you were on the night of July 1st?
Yes, I was at home with the kids and Tony.
What did you do?
It was a regular night, try to make sure that we have a family night with everyone. So we probably did what we typically do, which is watch TV. All the Disney movies start to blur together after a while.
What did you do at the end of the night?
We tucked the 2 kids into bed. Tony and I tucked the kids into bed, and then we went to sleep ourselves.
What time did you go to bed that night?
I can't say for certain, but kids want to make sure that they get to bed at a reasonable time. So just wanted to make sure we got them in bed at time.
What happened after you and Tony went to bed?
Well, we slept.
Where was Tony while you were sleeping?
He was right beside me the entire night.
How do you know that?
Well, I'm a really light sleeper, so if Tony were to make a move or if I heard anything, I would wake up.
When you woke up in the morning, where was Tony?
Tony was right there, right beside me.
Do you know where Tony was that night?
Yes, he was right beside me the entire night.
No further questions at this time?
Any cross-examination?
Yes, Your Honor.
You may proceed.
May I have a moment to confer with my co-counsel?
You may.
Ms. Hardaway, I'd like to talk to you about a flashlight. Someone in your home owns a flashlight.
Objection, relevance?
Your response is to relevance.
A flashlight was found at the scene. Permission to constructively approach, Your Honor?
You may.
Flashlight was found at the scene, and it matches the description of one that has been in the possession of Ms. Selena. Ms. Hardaway?
Ms. Hardaway, any response?
Your Honor, there's been no foundation laid that this is the same flashlight at all. I believe that at most the witness can testify that it was a silver flashlight. There must be hundreds of thousands of silver flashlights in existence.
Ultimately, I think goes to the weight. I think there's potential relevance, so I'll overrule. You may ask the question.
Yes, Your Honor. Someone in your home owns a flashlight.
I don't know for certain, but I do know that we have a flashlight.
So presumably someone in your home owns a flashlight.
I feel like most homes have flashlights, so yes, we probably own a flashlight.
And that flashlight is silver.
Yes, I believe so.
Shiny silver?
It is silver.
A shiny flashlight?
Yes.
You've not seen that flashlight since July 1st.
No, I have not.
Let's talk about your household. Ms. Hardaway, you like living with Tony Grove.
Yes, he's definitely a great father figure, and he always makes me feel really special.
I'm sorry if I was a little unclear. I need a yes or no, if you would. You like living with Tony?
Yes, I do.
Living without him would be hard.
Objection, relevance?
Your response.
It's permission to constructively approach her.
Of course.
It's relevant to evaluating the credibility of this witness to see that she has a bias in her testimony.
Bias is generally considered to be relevant. I think there's potential bias weight that can be given to that. The jury will decide what weight to give it, but I will overrule as to relevance. You may ask the question.
You like living with, living without Tony would be hard.
Well, I've lived with him for 1.5 years, and before that, I was pretty independent. I was able to take care of my 2 kids. I was able to maintain it. It would be hard if he went to jail, and I'd be sad if he was gone, but I'm very capable of handling myself without him as well.
So your testimony is that it would be hard.
Emotionally, yes.
Having Mr. Grubb around means your home has 2 incomes.
Yes. But he was unemployed for a little bit, and we were able to make things work.
Without his income, it's more difficult to pay your bills.
It is more difficult, but there's always family support. I have only lived with him for 1.5 years, so I was able to maintain independence before then.
In that 1.5 years, it has been easier for you to pay your bills with his income.
Yes, for sure.
The lease on your home is in his name.
It is. I moved in with him.
Having Tony around makes it easier when you have an unexpected expense like medicine.
Yes. When you have a youngest son who's sick, it's definitely helpful to have someone around for moral support as well as having a dual income.
When you needed money in July, Mr. Grubb is the one who came up with that money.
We pawned other things, but the necklace was one of the things that we had to get rid of.
And he is the one that came up with that money.
I do not recall.
He's the one who pawned it.
Yes, he was the person who pawned it.
As far as you can tell, the only item that was pawned is that necklace.
As far as I recall, but I'm not certain on that one.
I'd like to ask you about that necklace. Mr. Grubb gave it to you over dinner.
Yes, he did.
In fact, the two of you were out for dinner that night.
Yes, it was really thoughtful of him.
And Mr. Grubb had lost his job only days before that.
I do not recall that.
It was after he lost his job,
Yes, it was after he lost his job.
perhaps a week or so before you.
I wouldn't be able to give you the exact time because I don't know exactly when I received the necklace. I know it was sometime around the 4th of July, but I don't know anything outside of that.
You know it was before the 4th of July because you wore the necklace to a 4th of July party.
I know I wore it to a 4th of July party. Not sure if it was on the 4th of July or not.
When he gave you that necklace, he told you he found it on the ground in a parking lot?
Yes, he did.
You wanted to find the original owner.
Yes, I did want to.
You wanted to put up signs.
Yes.
But Mr. Grubb didn't want you to.
No, he didn't.
You wanted to put out an ad in the paper to find him, the original owner.
Yes, I did want to put an ad in the paper.
But again, Mr. Grubb didn't want you to do that.
Yes, he did not want me to.
In fact, he didn't want you to do anything to find the original owner.
The only suggestions we made were that I were to either maybe post an ad or a sign, so we didn't really discuss anything outside of those two areas.
I want to ask you some questions about July 1st, 2019. You didn't have any guests over to your home that night.
On July 1st,
July 1st, 2019.
we were at home, Tony and I were with the kids.
Your children sleep in their own beds.
Yes, they do.
It was only you and Mr. Grubb in your bedroom that night.
Yes, we put the kids to sleep beforehand.
You have a prescription for Ambien.
Yeah, I do.
On at least some occasions, you've taken Ambien.
Yep, on occasions. It really is something that helps me fall asleep. But after that, I'm a light sleeper. It's just helping me fall asleep. And then I'll wake up in the middle of the night or if I hear a noise or something like that.
Ambien is, in fact, a powerful sleeping aid.
It really depends on the person. So for me, it really just helps me fall asleep. But it really is dependent on the person.
So it helps you sleep.
It helps me fall asleep.
Is that I apologize if I'm unclear. I could use a yes or a no to that answer. It helps you sleep.
Yes, it helps me fall asleep.
You were asleep on the night of July 1st.
Yes, I was.
And when you went to sleep, Mr. Grubb was right next to you.
Yes, he was right next to me.
And when you woke up, he was next to you.
He was.
So you assume that he was asleep next to you the night.
Yes, I'm a really light sleeper, so if there's any movements, I'll wake up.
But you can't be certain what happens in a room while you're asleep.
I am pretty aware of what's around me.
So your testimony is that you know what's happening around you while you're asleep.
Say it again.
You're claiming that you know what happens while you're asleep.
I know, not always.
So you assume that Mr. Grubb was home because you did not wake up that night.
Yes, I'm a light sleeper, so if there's any movements or noise, I would notice for sure.
But you can't be certain what happened in the room while you were asleep.
No, I cannot.
So you can't be certain that Mr. Grubb was home while you were asleep.
I'm a light sleeper, so if he were to move, I would wake up.
So you are certain that you know what happened in the room while you were asleep.
I'm not certain, but for the most part, I can't say exactly what's happening, but yes, if there's a movement, I'll wake up. But I can't certainly say what's happening at all times.
So you can't be certain that he was home all night?
No.
Objection asked and answered.
I'll sustain. We've gotten that answer a couple of times, so I'll let you move to a different area.
May I have a moment to confer with my
You may.
counsel? You'll have to excuse me. I don't recall if you actually gave me an answer to this question. You can't be certain that Mr. Grubb was home.
Objection. Same question I just objected to.
She didn't, excuse me, Your Honor.
Go ahead.
She didn't give me a yes or no to that question?
Her answer was responsive. It doesn't necessarily have to be a yes or no. She'd indicated she couldn't be certain, so I agree that she didn't necessarily say the words no, but I'll sustain as asked and answered and let you proceed.
Yes, Your Honor. I have no further questions for this one.
Any redirect?
Yes, Your Honor. Ms. Hardaway, why do you have a prescription for Ambien?
I have it to take sometimes when I have difficulty falling asleep.
Did you take an Ambien on the night of July 1st?
I can't be certain that I did.
No further questions.
You may step down. Thank you.
You.
Does the defense have any additional witnesses?
We do not, Your Honor.
Does the defense rest?
The defense rests.
All right. Any other prior matters, I'm sorry, any additional matters before we proceed to closing arguments by the people?
The defense has none, Your Honor.
All right. Do people have any?
No, Your Honor.
All right. All right, at this point then, we'll go ahead and proceed to the next phase of the trial, which is the closing arguments, beginning with the state's closing argument. Are you ready to proceed?
Yes, Your Honor.
Mr. Jordan, when you're ready, go ahead.
He was out of money, he was out of options, and now he's out of luck. We're here today because a man broke into Elsie Stevens' condo. He surprised her while she was sleeping in bed. He ordered her out. He demanded her valuables. He took everything he could get, and he slunk off into the night. We know, from the facts that have been presented here, that the defendant, Tony Grubb, had just lost his job. And he decided to find cash the easy way. The defense would like us to add up all of the evidence we've seen. Call it coincidence. Call it bad luck. But piece by piece, we've shown that the man who was in her home was Tony Grubb. We've heard evidence today that proves that he was actually at that unit before. He knew how to break into a condo there. He knew the layout. We've heard testimony from Detective McIntyre about how he tracked down the necklace that was stolen from Ms. Stevens at the Lone Star Pond. No one contests that that necklace was in the possession of Mr. Grubb. We know he had a reason. He was fired from his job shortly before the burglary. My co-counsel and I have given you all of the pieces of this puzzle. Think of each piece of evidence as one of the little jigsaw pieces. It's time to put it all together. It's time to do what any reasonable person would do. Find Tony Grubb guilty. Guilty of burglary with assault and battery and grand theft. To be guilty of burglary with assault or battery, you'd have to conclude four things. The first is that Tony Grubb is the one who entered into Ms. Stevens' condo that night. You'd have to conclude that he entered without permission. It's actually undisputed that he has never been given permission to enter her home. Not that night, not any night, but his fingerprint was there. Third, you'd have to conclude that he had the intent to commit a crime when he entered. If you take a look in your jury instructions, as I'm sure that you will, you will find that you can conclude from the surrounding facts and evidence that he had that intent if the surrounding facts and evidence support that conclusion. You would have to conclude that when he entered, he did so, one, without her consent, and two, stealthily. That man who broke in that night, he did so late. He did so through a sliding door off the side. He did that to avoid being caught. To convict him of assault or battery in the commission of that burglary, you would have to conclude that when Mr. Grubb threatened Elsie Stevens, she believed that. She believed he would follow through on that threat, and that her belief in that was well-founded. You would have to believe that she felt that if she didn't do exactly what he said, she would be hurt. Ms. Stevens has testified today that she was terrified. Those are her words, not mine. He demanded her cash, her jewelry, her heirloom family silverware. During the incident, he held something shiny, something silver in his hand. Made it look like it was a gun. A shiny silver flashlight is in fact missing from the defendant's home. The other charge Mr. Grubb is facing is grand theft. In order to convict him of grand theft, you would have to conclude that he knowingly and unlawfully obtained someone else's property, and that he did so with the intent to deprive them of it, and so that he could profit from it. That necklace is the necklace that was taken from Ms. Stevens' home. You would also have to conclude that the value of the items that he'd taken was between $300 and $5,000. The necklace appraisal shows that that necklace alone was worth $375, to say nothing of the cash or the silverware that was taken, real silverware. The defendant is conclusively shown to have had that necklace because he is the one that pawned it. It's not a fact that's in dispute here today. Tony Grubb entered Ms. Stevens' condo. He did so without permission, with the intent to steal. And while doing so, he threatened her, and she believed him. Beyond a reasonable doubt, that's the standard of proof in this case. Well, it's not beyond a shadow of a doubt. It's not a speculative doubt. The only doubt that you have remaining is an unreasonable one. You must convict. Ms. Zinman and I have presented evidence that shows that the defendant is the man that broke in that night. Imagine these pieces of evidence as the pieces of a jigsaw puzzle. The fingerprint in her condo, that's a piece. Him pawning the necklace, that's another piece. The story he told to his girlfriend is another piece. His need for money, a piece of this puzzle. The dates that don't add up, one more piece, and so on. All of these pieces fit. They fit together. And if you look at the evidence that's presented, all the little pieces, and you think that this jigsaw puzzle is complete, and that the picture is clear, without a reasonable doubt that he did this, then you should find him guilty of burglary with assault or battery and grand theft. He won that necklace gambling on pool. For a man who just lost his income, he surely didn't seem to be worried about money. He says he won that necklace on the 6th, a Thursday. He says he gave it to his girlfriend on the 10th, a Monday. She's certain that she wore it to a 4th of July party. That's nearly a week earlier. Think about that. She has every reason in the world to lie to protect him, but she is certain that she wore that necklace to a 4th of July party. Doesn't add up. The one person who gambled and won that stolen necklace is the same person who has to explain his fingerprint in the victim's home. What a coincidence. Detective McIntyre has explained to you how the crime lab matched the print that was found on a package of candy to the defendant. No one has claimed that he was ever allowed in that condo. Not that night, never. It's undisputed. He had no income. He gave a gold necklace to his girlfriend at dinner, out to dinner. They sure had money to pay for that. The kids still had to eat. The bills still had to be paid. You'd think he would be desperate. What happened that night at Ms. Stevens' condo is he broke in. He demanded her cash, her jewelry, her silverware. The only connection she had to her dead sister. He took everything he wanted, right down to the candy out of her fridge. When she resisted, he threatened to hurt her. A widow, a sweet old lady, in her own home. He claims that he was home all night with Ms. Hardaway. To be fair, she said the same. But she assumes he was home. She has a prescription for Ambien. No one can be certain what happens in the room while they're asleep. What happened that night is when Ms. Hardaway fell asleep, he crept out of the room. He was out of money, he was out of options, and now he's out of luck. He went out for some fast cash. He had only one idea. He was going to break into someone's home. He was going to break in, and he was going to get whatever he could get. The defendant has been charged with burglary, with assault or battery, and grand theft. Do the reasonable thing. Convict him on these charges. The defendant blames the entire world. He blames his boss, says they were out to get him. He's insinuated that Miss Stevens had it coming, that her fight with her niece over some trivial matter brought this on herself. He blames everyone but himself for his mistakes. What we know is that he was in her home. His fingerprint was there. We know that he had a reason to do it. He was out of money. We know that he had the property that was taken from her home. He was out of cash. He was out of options. And now, he's out of luck.
Defense ready to give its closing argument.
Yes, Your Honor.
When you're ready, you may proceed.
Not investigated, not proven, not guilty. Today, the state failed. They failed Elsie Stevens, who called the state on July 1st and asked for its help. In response, the state did the bare minimum to investigate. They took a few notes, made a few calls, sat back and waited for a break. The state failed Tony Grubb, who went to bed on July 1st next to his partner, who had dreams of a family, a new job, future. Instead, Mr. Grubb is here today defending charges that the state cannot prove. And the state failed us. It's the state's job to protect us, to find real criminals. Instead, the state let the real criminal get away. They let Ace Hodges get away, and he's still out there. But I don't want to talk about Ace. I don't want to talk about where he is or what he might be doing because the state didn't find him and put him in front of you. I want to talk about Tony Grubb. Tony Grubb cares about family. Cares about children that aren't his in name but might as well be. And Tony Grubb cares about his name. So when the state put his name on the line, he walked in here, waived his constitutional right to stay silent, and he took the stand. He told you the truth. And in response, the state put forward the barest, most circumstantial case against him. Now, the state is required to prove its case beyond a reasonable doubt. Most folks have heard those words, beyond a reasonable doubt, but have never sat down and thought about what they mean. They mean that our society values liberty so highly that the state cannot take liberty away from any one of us before first proving that there are no material flaws in its case. Now, it's hard to think about that in the abstract, so think about it this way. Today, The state's standing at the edge of a canyon. And to prove a charge against Mr. Grubb, the state must build a bridge to the other side. Now, the state's brought 2 charges, so the state must build 2 bridges, one for burglary and one for grand theft. But the problem is this. The state has to build its bridge 1 plank of wood at a time. Puts a plank down, moves forward. Puts a plank down, moves forward. If the state uses a plank that has any cracks, any rot, anything that would compromise the board's integrity, the state puts it down and moves forward, the plank breaks. The state falls. Its charge fails. That crack is a reasonable doubt. Now, it doesn't matter whether the state falls at the first plank or the second or the last. If it falls, its charge fails. Now, both of the state's bridges are riddled with flaws. But there are a few I want to talk about in particular. The very first plank that the state tried to lay today for its burglary charge. The state must prove that Mr. Grubb knowingly and unlawfully entered property belonging to Ms. Stevens. This plank is riddled with flaws. First off, there's a huge crack in it. Miss Elsie Stevens' memory. She was standing in the same room as the robber, and she can't identify him. You heard the detective today say he showed her a photograph of Mr. Grubb, and she couldn't identify him as the robber. You saw Miss Stevens look around today and say, I can't recognize the robber's face. If Miss Stevens has doubts about who the robber was, shouldn't you? Second, this board is warped because the state's mischaracterized the only evidence found in Miss Stevens' apartment, a flashlight and a fingerprint. Now, you heard Miss Stevens today say that she doesn't remember whether the robber was wearing gloves. But you heard her testify that the robber opened the refrigerator door. If the robber's fingerprint got on the package of candy, wouldn't his fingerprints be on the refrigerator door or on the door to the house? Doesn't it make more sense that he was just wearing gloves? Mr. Grubb's fingerprint got on that package of candy because he worked in a stock room at the grocery store where Miss Stevens shops. You saw today that he worked 80 hours in the weeks leading up to when Miss Stevens bought that package of candy. How many packages must he have touched in that time? Lastly, this plank has a huge hole in it, Ace Hodges. You know the defendant got the necklace from him, the defendant testified about it. You know he was a person of interest, the detective testified about it. But the state never bothered to find him. Without Ace Hodges here, the state put this plank down, moved forward, and it broke. So let's move on to the second bridge, grand theft. Very first plank, state must prove that Mr. Grubb knowingly and unlawfully obtained property belonging to Ms. Stevens. Now, we've heard a lot today about unique links, how unique the links in this necklace were, but you also heard that Ms. Stevens bought it from a department store. God knows how many others exactly like it are out there. How unique could it possibly be? There was no pendant, no identifying marks that would make her certain that the 2 necklaces are even the same. And if they were the same, we know that Mr. Grubb didn't knowingly and unlawfully obtain it from Ms. Stevens. He won it in a bet from Ace Hodges. So there's a hole in this board too. If the state believes that Ace Hodges stole that necklace from Ms. Stevens, the state should go out and find Ace Hodges. Maybe they'll find the rest of Ms. Stevens' property when they do. State put this plank down, move forward, and it broke. Now, this last plank is the weakest of all. The state must prove that the value of the property obtained was between $300 and $5,000. You know that that's not true. We're not talking about the value of Ms. Stevens' silverware because the state never proved that Mr. Grubb ever had any silverware, let alone what it's worth. You heard Ms. Stevens say she has no idea. You saw an appraisal today that necklace 3 years ago was worth $375, but we have no idea who performed this appraisal. Whether they just Googled gold necklaces, what are they worth? We have no idea whether this is reliable. You know that in 2019, this necklace sold for $200. Current day value is $200 because it's worth $200. What we know is that the state cannot meet the minimum requirement required of it by law. Instead of a plank, they used a twig. State moved forward, and that twig broke. Now, in a few moments, you'll be asked to go into a room and think back on the state's case. I want you to think about the bridges that they've tried to build. Think about all the cracks, all the holes, all the rot, all the rusty nails in those bridges. Ask yourself, do you want to walk across that bridge? Do you? You'll be given this form. As to count 1, burglary with assault or battery, mark not guilty, because you know that charge wasn't fully investigated. As to count 2, grand theft, mark not guilty, because you know that charge wasn't proven. Find the defendant not guilty, because you know he's not.
How are we on time, by the way, for closings? You don't have to use 10 minutes,
Yes, Your Honor.
but you may proceed.
I'd like to remind you, only one man was connected to the physical evidence that was recovered from Ms. Stevens' condo. One man. And that one man was matched to that by a fingerprint, and that one man had broken into that same complex before. They say that the police should have tracked down Ace Hodges. The police looked. What's the point in expending the police resources when we know that one man was there? And we know that that one man had property that was stolen from her home. They say that a professionally made jewelry appraisal is not reliable, that maybe they just Googled it off the internet. That appraisal gives you the weight of the gold. That appraisal tells you the method of manufacture. Does that sound like an amateur? Does that sound like someone Googling gold necklaces on the internet? Let's go to the heart of the defense's theory. What they're asking us to believe. They are trying to get us to believe that that fingerprint was placed on that package of candy at least several days, possibly a week, possibly more, before Ms. Stevens purchased it. Now, think about that. A fingerprint on plastic wrap, on a package of candy. I mean that no one came in, slid it around on the shelf, maybe shuffled it around and bumped it. That print could easily rub off. It could easily smudge. A fingerprint in plastic wrap. That would mean that when Miss Stevens came in that day, doing her grocery shopping, she picked it up off the shelf, she tossed it in her cart with the rest of her groceries. She maybe continued shopping, came up to the front. She put it on the conveyor belt. The clerk picked it up, scanned it, handed it to the bagger, dropped it in a bag with the rest of her stuff. And that whole time, that one fingerprint stayed perfectly intact. She took it home. She unpacked her groceries. She put the candy in the fridge. She took it out. Had a bar. There were 2 missing. She put it back in the fridge. She did all of that. And that one fragile little fingerprint didn't break. Does that sound reasonable? Or is the simple, most logical explanation the reasonable one? That in a moment of carelessness, while he was in her home that night, the defendant left that fingerprint. That's the reasonable explanation. We've bridged that gap. The evidence is clear. It's time to convict Mr. Tony Grubb. Find him guilty beyond a reasonable doubt. He is the person that did this. Find him guilty of burglary, assault or battery, and grand theft.
First, congratulations. I think we'll step out at this point and finish our score sheets. We'll be right back. We won't do a critique at this point. I know that there's some food and some drinks afterwards. Many of us are staying behind. If you have individual questions, we'd be happy to give you thoughts and observations and critique. We did want to at least introduce ourselves so that you know who is making the decision before we give you that decision. I'll start with both my panelists. Actually, we should ladies first. Judge Martinez, please go ahead. I should turn the microphone on, so, oh my gosh.
Scared me. All
Go
right,
ahead.
I think, are we good? Can you hear me? All right. Hi, my name is Christy Martinez, and I'm a presiding county court judge in the 21st Judicial District here in Boulder, and so not too far from you. And if I can just say one thing, just in case people leave, I am remarkably impressed with your professionalism here today, how you treated one another and how you treated opposing in terms of your colleagues and also opposing counsel. It is just really lovely to see, and it makes me feel really happy because those things matter in terms of how we see things. And I know we weren't going to give feedback, but I couldn't help it. It's my particular thing, and it was just really lovely to see. You guys are so impressive.
And at least you four know I'm Mike Thompson because I've been on other trials of yours this weekend. And plaintiff civil attorney for the last 20 years at Purvis Gray Thompson. And it's been really cool to be involved in this weekend and see how terrific all of you are. I could not agree more about the professionalism. I don't sit on the bench. These guys do that, and which is wonderful. But I think the professionalism side of this is so important in what we do, that even more if you're going to choose to be a trial attorney, because you're going to be in a setting of competition. But you guys did a great job of showing you can compete hard, and there was some real good hard competing done in this trial, and you did it without getting angry or looking down on your opponents, all those things. And seasoned attorneys screw those things up.
My name is John Madden. I'm a Denver District Court judge. I'll throw some other things out also because I get booed on the other side, so I'll throw it out. I'm one of the coaches of DU's law school team on their trial team. So later when you do the CU-DU Cup, you'll see me down there. I've also helped coach up at CU in terms of their trial team a little bit. I've coached undergraduate high school at CU and undergraduate mock trial at the college level at CU and DU. And I'm the chair of the Colorado High School Mock Trial Association in terms of the high school mock trial competitions. It's a long way of saying I love this process of watching mock trial. I'm presently presiding over a 2-week high-level media coverage felony. We have cameras in the courtroom this week. And Judge Martinez said, well, but why are you here? And I said, because this I really enjoy. I love seeing the enthusiasm. I love seeing the effort and the skill. And I agree completely with what's been said. The professionalism has been outstanding, especially for 1L students. It's really great to see. With that, though, certainly, as I've indicated, we're happy to give you more feedback and more specific comments. But it's late. You've been going a long time. You don't have another round to go to at this point. And so we should get to the winner at this point. First, congratulations to both of you for getting here. That is an amazing accomplishment. That's a fight up and down the ways where things can go wrong in ways you wouldn't expect. You wouldn't be here. It was a fabulous round, and without further ado, we did have a unanimous decision. It was relatively close, within a few points per ballot, but it was a 3-way decision. The winner of this case was the defense. Congratulations to our defense counsel. So, Mr. Harrison, Mr. Stevenson, congratulations. But Mr. Jordan and Ms. Zinman, thank you as well. You did a wonderful job, and we'd be happy to go back and tell you more comments back there. And congratulations again. Yes.
Oh, sure. Oh, yes, of course.
Absolutely.
No, that's fine.
You absolutely should take pictures, yes.
By the way, thank you so much for doing this. I'm so impressed with what you guys did. You can just leave Just thank you for doing this.
Oh,
It's really, really impressive.
Really,
Yeah.
I wish more firms would take this
It's such a
seriously.
commitment. It's so amazing.